Before we get started, I just want to test. Tracy, can you hear me?
Yes, I can.
Thank you.
Yes.
Good morning, everyone. We are on the record in the Colorado Public Utilities Commission's proceeding number 25A-0385W. I'm Kelly Rosenberg, the administrative law judge assigned to this proceeding. This matter is regarding Cascade New Vision LLC's application for approval of simplified regulatory treatment and a one-time increase in rates for water, sewer, and system development charges. This evidentiary hearing was set by a prior interim decision in this proceeding. And I have some general advisements for everyone before we get started. First, this matter is being recorded and webcast on the Commission's website, and we have a court reporter taking down every word stated. If I mispronounce anyone's name or if I use an incorrect gender pronoun, I mean no disrespect, please correct me. And if I do it twice, correct me again, but I will do my best to correct myself after the first time. I'm sure this goes without saying, but I do say this at the outset of all of my hearings. Treat each other with respect. I won't tolerate disrespectful behavior to each other. And I know I will need periodic water and rest breaks and a lunch break, so you can plan on regular short breaks. If you need a break at any point, let me know, but we're going to really endeavor to do it at times that make most sense during the proceeding, like not mid-question, for example. And then a few more specific preliminary matters that I have. And just, of course, I will let the parties advise of any preliminary matters, and you all have the opportunity to respond before we get going. First, I have read everything in this case that has been filed. Saying it twice doesn't make it have more impact, so I would like to limit having witnesses read portions of pre-file testimony. I appreciate that there are times where it can be most efficient to have snippets of pre-file testimony be reread, but usually it isn't that helpful, so please keep that in mind. No recross will be allowed, which is not unusual in these types of cases. And at the outset, I'm letting the parties know that I'm going to put a very tight deadline and page limit on the statements of position. As you proceed during the hearing, keep that in mind. They will be due by close of business Monday, May 4th, and limited to 13 pages, exclusive of caption, signature block, and certificate of service. Again, I've had plenty of time to review all the materials in this case, and I am familiar with the parties' positions. So these closing statements, you can rest assured that I've read everything that's in the record. Regarding confidential session, in the event we need to go into confidential session, it will be far more efficient if you group all of your confidential questions so we only go into confidential session once. I understand this could affect the continuity of your questions, but I want to do it once, if at all. And I want the parties to know that I will entirely rely on you to police the participants in the confidential session. And so I'm counting on you to alert me if there are people in there who don't belong. Let's see. So Cascade, I do have a question for you regarding, and actually the first question, which we'll get to a little bit later, but what was, I think, filed in with the rebuttal is CLM-3. Is that the correct exhibit number for that at the outset? That's the first question.
Good morning, Your Honor. Mark Davidson, law firm Fairfield and Woods, appearing on behalf of the applicant Cascade New Vision LLC. And your question is with respect to attachment CLM-3?
Yes, the right water engineering report.
Yes, and what is the question?
What is that actually CLM-3? Is that the correct
There is
nomenclature for
there
that?
is a right water report that is marked as that attachment number. There's another right water report that has a different designation. That's, I believe, CLM
8?
8. Yeah, yes, ma'am.
Okay. Is 8 the March version?
Correct.
Okay. All right. My question for you then, and thank you for that. I've had difficulty personally with this spreadsheet, which is not anybody's fault. So I've been going back and forth between what's been filed in e-filings and then the spreadsheet, and I think there were a couple of areas where I was a bit confused. The substantive question for you is page 6 is a pretty detailed 31-column spreadsheet. Is it possible for you to provide that as an executable document?
I'll have to say maybe. I'll have to check
Okay.
the
Okay.
consulting firm that developed that spreadsheet to see if that's available in that format. But I can do that on a break this morning.
Okay, great. Yeah, and it's not something that would be needed right now. But if you could check into that, that would be great, and let me know throughout at some point.
I will do so.
And then finally, my last general advisement is I don't want speaking objections. You certainly can object whenever you think it's warranted, but you just need to state the basis. If I need further explanation, and I will ask for it. But if you believe something is here, say, for example, just say objection hearsay. I have found that hearings can quickly devolve and there could be quick side arguments between counsel, and I want to avoid that. So just an advisement, if you have an objection, just state the basis and I will look to each party, but everyone will get an opportunity to provide a response. I just ask that people wait until they are acknowledged before doing so. And unless I specify otherwise, I'll generally go in this order when I ask the parties something. And so the first thing I would like to do is have the parties enter appearance, beginning with applicants.
Yes, good morning, Your Honor. Mark Davidson, law firm Fairfield and Woods, appearing on behalf of the applicant, Cascade New Vision LLC.
Thank you. Good morning. Thank you for being here. And now staff.
Good morning, Your Honor. Justin Larson with the Colorado Department of Law, Assistant Attorney General. I am here on behalf of the Commission's trial staff, and with me today is Dr. Deepesh Tapu, who submitted answer testimony and will be available for questioning.
Thank you. Good morning, and thank you for being here. And finally, what I refer to, and I will refer to just because I've become accustomed to it, the association. You can refer to yourself, and the parties can refer to the association in whatever manner works best for them.
Good morning, Your Honor. Mark Detsky, the law firm of Dietze and Davis, entering my appearance on behalf of Cascade Village Condominium Association. I've been calling it CVCA. I will try to call it the association.
I've noticed in the writings that I call it something different, and I don't know if I'm able to change it, but you don't need to change your reference.
And thank you. I'd also like to enter the appearance of my co-counsel, Rebecca Townsend.
Thank you for being here. Good morning. And now I'd like to move on to the exhibits. We are conducting this hearing utilizing electronic pre-filed exhibits as much as practicable. A spreadsheet has been prepared to navigate documents pre-filed in the Commission's administrative record, and that spreadsheet was provided to you last week and is marked as hearing exhibit 400. It reflects the date of the latest filed version of each exhibit as it appears in the Commission's administrative record. A title reference for hearing exhibits that will be utilized during the hearing, and the titles of the hearing exhibit as reflected in the Commission's records. Any exhibit listed in the spreadsheet that is admitted into evidence will be admitted by administrative notice based upon the existing filing referenced in the commission's file. As such, those portions of the administrative record would become part of the evidentiary record. And the exhibits identified on the party's exhibit spreadsheet that have been pre-filed into this proceeding are admitted into evidence subject to any objections noted on the record. So at this time, I do want to check with the parties and find out if any of the parties object to the exhibits in the spreadsheet, beginning with applicant.
No objection, Your Honor.
All right, thank you. Staff?
Yes, I don't know if this is a question or an objection, but the spreadsheet, I think, are we referring to the one that we are referring to the one that was sent out last week, correct?
Yes.
Okay, because my understanding is that the company refiled some of the exhibits, I think yesterday, and I was just kind of pouring through them this morning because e-filings was, as I'm sure you know, have some issues yesterday. And so I'm trying to understand which exhibits are going to be admitted based on this and what was filed yesterday. And I was hoping we could kind of go through the process of like reconciling that because many of those exhibits in the current spreadsheet are exhibits that were from the prior filing that were erroneously included.
My understanding is that staff spoke, I don't know if everyone was on email, but I understand, I'm aware of this issue. My understanding was that Cascade was going to move for the admission of those later filed exhibits and through the box.com process. But Mr. Davidson, please go ahead and clarify anything.
That's correct, Your Honor. Your question was whether Exhibit 400 as proposed was acceptable, and it is, as that was filed or included in the commission's file when it was prepared. I do have, as Mr. Larson's indicated, some, I'll say, updates to that we have put in the box, the company's box that I was going to move for admission once you were through this part of the process.
Okay, great. And that was actually next on my list too. So Mr. Larson, so yes, this goes specifically to the spreadsheet 400 as it was provided to you last week. And with that, does staff have any objection to those exhibits?
Yes, so I think I would object to the exhibits. Let's see, it would be 100 Rev 1, the direct testimony, and CLM 1 through 5 as they're reflected, Rev 1 in the spreadsheet, because those were all filings from the prior case. If I'm understanding correctly.
And Mr. Davidson, do you have any clarifying or any remarks about that?
Yes, Your Honor. I think trying to think the best way to explain this. When we filed the Rev 1 direct testimony, which was intended to only add headers to the original version of the testimony, unfortunately, we filed as that document a version from another Cascade proceeding. So we then filed what was now Rev 2, which was the original direct testimony filed with the application without a docket number, proceeding number at the time, of course, because that was the initiating filing for the case. So I think Mr. Larson is correct that the original direct testimony Rev 1 can be excluded from the record, and we have replaced it with Rev 2.
Okay, and the Rev 2 is what is in the box.com.
Correct.
Oh, and I see actually that go ahead, Ms. Federico or Ms. Crane. I'm not sure who it is.
It's me, it's Casey. So I just want to make sure because Mr. Larson mentioned attachments too, but I think Mr. Davidson only mentioned the testimony itself. I'm only taking from box this hearing exhibit 100 revision 2. I don't see any of the CLMs 1 through 5 in box, so I'm just confirming that I'm not missing anything.
You're not, if I may, Your Honor. CLM 1 through 4 were attachments to the original application. And in an effort to simplify things, which unfortunately didn't work, we renumbered those. But we have refiled the original application and exhibits, or excuse me, attachment numbers 1, 2, 3, and 4 to the original application in our box as Rev 1 hearing exhibits and attachments.
And
So-
then the 5 through 8. Oh, go ahead, Casey. Go ahead.
No, I was just asking, so am I also moving those over or not? That's all.
Well, yes, we will ask that those be moved over into the evidentiary record as the, I'll say, updated or corrected versions of the original filing that we made last Thursday, I want to say.
Okay, so that's 102 and attachments 1, 2, 3, and 4 to 102, revision 1 of all of those.
Correct.
Casey, were you done right now?
Yes, I'm all done. Sorry about that.
Yeah, and yeah, no, I appreciate it. Mr. Detsky, did you have a comment?
Yeah, I'm sorry. I'm just trying to follow along. So,
Yeah.
so there is no attachment 5 that was filed with this case. So from what I understand, then Mr. Davidson has, when you filed the rebuttal testimony, Rev 1, and you renumbered 7, 8, 9, 10 exhibits, those are the same ones as the ones you filed earlier in this case. Is that correct? I'm sorry, not cross-examining you.
It's okay, if I may, Your Honor. Yes, attachments CLM 7, 8, 9, and 10 were filed originally with the rebuttal testimony of Mr. McAlpine. And, excuse me, those would be in the original filing from last Thursday.
So if those are correct, then there will be no attached. There will be no CLM 5 and no CLM 6. It would go 1 to 4 and then skip 7 to 10.
I'll make 2 clarifications. One is we would, from our box, move in CLM 6, which was the supplement to the application that we filed back in October, I want to say, last year. CLM 5 is actually included in CLM 4. That financial spreadsheet, I think it's a profit and loss statement, was a second part of CLM 4. So just to be clear, it's in CLM 4, but we're not asking it to be a separate attachment, to your point.
Can you identify which pages of CLM 4 it is?
I can. Let's see. I think it's going to be, so I can identify the document. How's that? It's the profit and loss statement showing dates from December 31, 2021 through December 24, 2024. And it's the second part, if you will, or attached to the earlier version of the financial profit and loss statement in attachment 4, or excuse me, CLM 4 as well. So I didn't want to be unclear that the document will be in the record, but it's not going to be marked as CLM 5.
Okay. Mr. Detsky, did you have any other questions?
Not on this particular piece. Before I start into my first cross, I may want to take a couple of minutes to see if I have the exhibit numbers right. And I think this might get messed up a couple of times.
Well, yes, and I was wondering to that end, actually, Mr. Davidson, if you would be able to potentially at a break, and we could even take a break now if it's easiest for everyone. Take like 10 minutes or 15 minutes to maybe send an email to all of us, sort of clarifying what is no longer relevant on spreadsheet exhibit 400, and then what is replacing the CLM 1 to 4 and where the CLM 5 goes, just so we're all a little bit clear about what's what.
Sure, I can do however you prefer, Your Honor. Whatever we can start and see if it works, but I can certainly take the time now to sort this out before we
Well,
start.
if you don't mind, and if the parties are actually okay with this, I would prefer if we take a few minutes now just to get this sorted out. I don't think it's really a point of contention, more a point of confusion potentially. And so I'm thinking we may avoid the confusion if we get it clarified at the outset.
That's fine. And I apologize, Your Honor, for the confusion here. There were a lot of
Okay.
documents that were moving around, and the commission system was down over the weekend, so we
Right,
couldn't. Anyway, I apologize.
Yeah, no, I understand. It's these sorts of things do happen. Why don't can we take a break till 9:30? See
Sure.
if that, okay. All right,
I
so
think I
let's,
can do it within that time.
and if you need a couple extra minutes, I mean, we'll check in at 9:30. If you're not here yet, we'll come back a couple of minutes later. But otherwise, everybody will take a break until 9:30.
Thank you, Your Honor.
Thank you. We'll go off the record for 10 minutes or so. I'm just checking back in. We are not yet back on the record. I'm just seeing if Mr. Davidson had a update. And he may not be. Okay. As I mentioned, we may take a few extra minutes. So yes, although we're not back on the record yet. So why don't let's hold off a couple more minutes and then I'll be back, Mr. Detsky, and we'll go back on the record in a couple of minutes. So I'll come back in about 2 minutes or so. We can check in then, and then I'll take your comment. Okay. Mr. Davidson, are you here?
Yes, Your Honor.
Okay, great. Why don't we go back on the record now? And Mr. Detsky, during the break, Mr. Davidson, Mr. Detsky raised his hand, and I said, let's wait till we go on the record. But go ahead, Mr. Detsky.
Thank you, Your Honor. We checked over the break and attachment CLM5 is not included as any page in attachment 1024. They are they're different numbers, different formatting, different dates.
Okay, thank you for that. Mr. Davidson, did you have any input on that?
I don't at the moment, Your Honor. I'll have to check again on a break and see if I can sort that out. I was busy trying to send you the list of, I think, what everything is from our box, as well as has been included in Exhibit 400.
Okay, all right. Thank you for that. Can you remind me again what CLM5 is? I know you talked about it. I just, all the numbers,
Yeah, it's a profit and loss statement of the company. From the dates are December 31, 21 through December 2024.
Okay, well, let's see. I'm not quite sure. And Mr. Larson, starting with you, and I understand we just received this email, so this isn't, I'm not putting you on the spot here. I don't, but can you let me know with regard to hearing exhibit 400? Let's do that again. Can you let me know what your objections are to exhibits on 400?
So here's my understanding, Your Honor, and I can totally try to I think what Mr. Davidson, before we went to break, had moved for the admission of the filings, the updated or not updated, but the application with original, with new labeling and all of that, and then the 4 attachments to the application, correct? So far, so good. Okay, and so those 4 attachments are attachments 1 through 4 are now going to be attachments 1 through 4, Rev 1 to Exhibit 104 or 102 rather. Excuse me.
Correct.
Then the McAlpine Direct Rev 2 is going to be hearing Exhibit 100.
Yes.
And the in the spreadsheet, attachments CLM 1 through CLM 4 were just duplications of the 4 attachments with the application that were just admitted as 102 Rev 1.
Correct.
Okay, and then I think then the only that we could just that would be replacing, those would replace all of the in the spreadsheet CLM 1 through 4, as well as the direct testimony of Charles McAlpine, which you thought is now going to be the Rev 2 version.
Correct.
Okay. So then we would be, I guess then now I don't understand why we would need to move into evidence basically the first 6 items in this spreadsheet, Exhibit 400, because now they've all been replaced, right? Is that?
I think that I'm just looking at count 6 items.
And then CLM 1 and CLM 5 was just not to be included.
I think that's correct. That clarifies where I think we end up. Yes.
Okay,
Your Honor, I'll just note that
yes,
just based on this discussion, I will have some questions around CLM 5 and may seek to move that in, but we can move that in later, keep it out now.
I have no objection to including it. I just it was just for clarity more than anything else.
yes. I think the issue though is that at this time, it doesn't appear to have been proffered to be moved into evidence, but yes, Mr. Deskey, when we get there, if you can just raise it and then we can get it moved in at that time, that's fine, unless,
I'm happy to move it now, Your
yeah,
Honor.
okay.
That helps the record.
Yeah, and then can you put that up into the box.com account as well?
Yes.
Okay,
We'll do
so
that.
I believe where we are now is the first 1, 2, 3, 4, the first 6 items on the spreadsheet are not being moved into, those will be excluded from the spreadsheet. Everything else, the parties, staff doesn't object to, as I understand. What about the association?
No objection to this revised proposal.
Okay, all right. So then at this time, we'll move Exhibit 400 and then therefore all the underlying documents into evidence with the exception of the first 6 that are listed. And then Mr. Davidson, if you, I don't think the parties object then to the exhibits in Mr. Davidson's in the box.com folder. Staff, do you have any objections to those being moved into evidence?
No objections other than I haven't seen them, so I mean I'm assuming
Okay.
that they're the same as the originals, but subject to check later
Yeah.
on if we do discover something. I think
Why
I
don't
could
we do
agree
that?
to that.
Why don't we do that? We'll hold off on getting those into evidence once Mr. Davidson moves to admit them, but then also to allow the parties some time. So this afternoon, we'll circle back to that and at that time, if the parties need more time, that's fine too. We can deal with it later. But does that work for the association?
Yes, Your Honor.
Okay, and I assume that works for you for Cascade as well, Mr. Davidson.
Yes, Your Honor. I think Mr. Larson correctly indicated that those are the materials in the box that we're referring to now are just the updated, corrected versions of the first 6 items in Exhibit 400 that now include the proper headers, et cetera. So,
Okay, let me just, one thing, I just want to confer internally here.
okay.
And then I will. Okay. Okay. All right. So now moving on to Cascade, do you have any preliminary matters before we get started?
None other than the ones that we've just gone through, Your Honor. And again, I apologize for the confusion and the multiple filings of the various materials that I think we've now clarified what they are, and the revised versions are the corrected ones.
Okay, great. Thank you for that. Staff, preliminary matters?
Nothing further from staff. Thank you, Your Honor.
Thank you. And the association?
Yes, Your Honor, just a couple of small things. As far as I am aware, the only confidential exhibit is WB3. And I've tried to put any questions I have together on that. But if it needs to refresh recollection or something like that, that may come up.
Okay.
I would also just wanted to give the heads up to you that I am going to be moving on during my cross a few exhibits based on administrative notice. And I have a demonstrative exhibit. There are a lot of numbers floating around here. And so I prepared a demonstrative based on evidence already in the record to help the efficiency of the hearing.
Great. Thank you. Thank you for letting me know that. Okay. Wonderful. All right. Well, with that, let's move on to the evidentiary portion of the hearing. Cascade, do you mind? Would you tender your first witness for cross-examination?
Yes, thank you, Your Honor. The applicant would call Mr. Charles Lindsay McAlpine.
Thank you. Good morning, Mr. McAlpine. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Great. Thank you. And staff, would you like to proceed first? That's, as I said, that's how I had it arranged, but if the parties had a different order, you could do that, but otherwise let's have staff go.
Yeah, Your Honor, I think that we had talked about this amongst the parties when we were preparing the matrix, that staff would be fine with the association going first. I know that they have a number of different
Great.
areas that they're going to cover that we weren't planning to, so we're fine with that if they're okay with it.
Kind of what I thought, which is why I sort of made that qualification. So yes, okay, Mr. Detsky, go ahead.
Thank you, Your Honor. Mr. McAlpine, good morning.
Good morning.
I am Mark Detsky. I'm counsel for the association. I'm going to be talking with you today about your testimony and the attachments and the reports that you filed with your attachments. I have going to divide this up into 2 parts, if you will. The first part, we're going to talk about the rate increase and the various profit and loss statements and balance sheets that you filed and the future growth of the utility. In the second part, we're going to talk more about the loans and the lease and the affiliate transactions. As a bit of background, I wanted to start off though first and ask you, what is the relationship between Cascade New Vision and Grizzly Peak Water Sales and Distribution LLC, which I'll call Grizzly Peak?
Cascade New Vision is I think Grizzly Peak, sorry, I've got a head cold. It's taking me a second. Grizzly Peak is the doing business as it had been referred to as Grizzly Peak all along, and Cascade New Vision owns that entity.
And Cascade New Vision is the member of the Grizzly Peak LLC by virtue of the membership interest purchase agreement from August 2021. Is that correct?
I believe that's correct.
Okay. In discovery, you said that Cascade is the regulated entity and operates Grizzly Peak. Is that correct?
I believe that's correct.
Okay. But you admit that CNV does not keep separate books and records from Grizzly Peak. Is that correct?
I'd have to check with the bookkeeper, but I think that's incorrect. I think
So go ahead.
C and V, as you referred to it, is the entity that's approved with the commission, and it keeps all the books and records.
Okay, so that's what I'm trying to establish. There's no difference between Grizzly Peak's books and records and Cascade's books and records. Is that correct?
That's my understanding.
Okay. And about how many ratepayers does Cascade have?
This is off the top of my head, but I think it's just below 200, including the owners at Cascade Village and the Colorado Department of Transportation.
In your rebuttal, you said 160. Does that sound right?
Yes, I'm doing it from memory, so for some reason, I think it's slightly higher.
Well, we can pull up your rebuttal if you want to see it. Ms. Federico, thank you. Could you please put up hearing exhibit 103, Rev 2, I believe we're on? Is that correct?
No, it's Rev 1.
Rev 1.
As far as I
Okay.
know.
And I am looking at page 2, lines 19 through 21. Do you see there, Mr. McAlpine, that you said 160 service drops?
Said approximately 160.
Okay. And thank you, Ms. Federico. I think that's put this down for a second. And Cascade has at least 2 rate classes, one for residential customers and one for the association's common building. Is that correct?
I believe that's right.
Okay. And this common building, the benchmark building, there is no rate increase noticed for this class, correct?
I'd have to refer to our file documents.
Okay. We can pull up what it was Exhibit 1 to your application, which was a notice.
Sorry, since the numbers. We're talking about hearing exhibit 102, attachment 1, articles of organization.
No. It's well, we'll have to, I'm not sure how it might have changed. Oh, I have Exhibit 1 rate change notice is what it was called.
So I need some kind of number. So Mr. Davidson, if you know what it is.
If I may, Your Honor, I believe, Mr. Detsky, that was a file, it's in the commission's file. It was the certification of the notice to customers that we submitted to the commission after the notice was delivered to customers via bill inserts. And it's not part of the materials that we have asked to be admitted in the record. So might have to pull it up and use it as a cross-examination exhibit if you want to move further.
Okay. We will, Your Honor, can we come back to that? It'll take us a minute to upload that to our box to get it in there.
Yes, of course.
Okay. Thank you. I'll move on for now if that's okay.
Yes.
Okay. Mr. McAlpine, you argued in your direct testimony that one of the principal reasons for the commission to grant this rate increase is that a rate increase has not occurred for this utility since 2012. Is that correct?
think it's been at least that long, yes.
But in terms of bringing this rate increase to the commission, that decision was yours, correct?
To request a rate increase?
Yes.
Yes.
And you would acknowledge, wouldn't you, that that is par for the course? Utilities generally have the right to decide for themselves when to bring a rate increase to the commission. Isn't that correct?
I don't know how other utilities operate. I assume that's correct.
So if the prior utility did not file a rate case between 2012 and 2021 when you purchased the utility, that was the decision of that utility. Isn't that correct?
Again, I think you're asking me a question that probably is best answered by the previous owners. I don't
But-
know what their motivation was to file or not file.
Correct. I'm not asking you to guess at their motivations. I'm just saying that you acknowledge that just like this case was your decision to bring a rate increase, it would have been the other utility's decision whether or not to bring a rate case for themselves, regardless of whether they did or not, correct?
Yes.
So one thing we could possibly infer is that if a utility does not bring a rate case for 10 years, the utility was okay with their rates. Isn't that correct?
Your
No.
Honor, I object. This calls for speculation on Mr. McAlpine's part. He was not the owner during the 10-year.
Okay, remember, no speaking objections. I understand the issue. Yes. I agree that that is seeking speculation, but Mr. Detsky, did you have a response to that?
Your Honor, I'm asking him to speculate not as to the motivations of, but just to infer that if this case was his choice to bring, so too would it be the choice of the prior utilities to bring.
I understand that inference that what you're getting at. I will go ahead and sustain this objection because the inference is requiring Mr. McAlpine to make speculation, but you've made your point.
Thank you. I'll move on. Mr. McAlpine, in your direct testimony, Cascade requested a 27% residential rate increase. Is that correct?
I believe that's correct.
And in your direct, you stated that the proposal to increase rates by 27% was not based on the cost of service, but instead was based on applying a 2% per year inflation factor for the 13.5 years from 2012 to 25. Is that correct?
No, that may have been one of the factors considered, but we considered the actual cost of services, the regulatory requirements, the outside consultants' scope of future requirements. We considered quite a few variables, not just inflation.
Ms. Federico, can you please open hearing exhibit 100, Rev 2, the McAlpine Direct at page 5, please? And I'm at line 18. Mr. McAlpine, do you see where you say your proposal is driven simply by applying an average inflation factor of 2% for the past 13 years?
I do see that.
Okay, thank you. And thank you, Ms. Federico. I don't need this up right now. And you talked about your costs, but isn't it true that in your rebuttal, you state you did not perform a cost of service study? Isn't that correct?
We didn't perform a third-party cost of service study, but we certainly understood actual cost of services, billings that we were receiving in working with the utility.
So Mr. Burkett, in his answer testimony, pointed out that your 27% noticed increase was actually a 37% rate increase, correct?
I don't speak for Mr. Burkett.
Okay. And when you were asked about the discrepancy in your rebuttal, you responded that you did not know how, or sorry, when you asked about it in discovery, not rebuttal, you responded that you did not know why the math ended up at 37% versus 27%. Isn't that correct?
If that's what my response was, yes.
Okay, and we can turn to it if you'd like to see it.
We can do that if you like.
Okay. I think you've answered the question. Can we please turn to your rebuttal, Ms. Federico, hearing exhibit 103, Rev 2, at page 6?
For the record, we're still on Rev 1 for this one.
Oh, sorry. I'll get that right eventually, I promise. Line 22, please. Okay. And here you say at the bottom here, you say, while the percentage appears that the application notice was incorrect at 27%, the actual dollar amount of the proposed increase was accurate. Do you see that?
I do see that.
Okay. Why is the 37% dollar figure accurate?
I think there might have been a clerical error in the filings, frankly. I don't know.
Well, the 27% was accurate if you had based it on 2% per year times 13 years. That would have 13 and a half years. That would have given you 27%, correct?
If you say so.
So
Just goes to show that we didn't use 2% CPI.
well, your testimony was that you did, correct?
That my testimony was that was part of our analysis. We looked at a variety of things.
Okay. In discovery, we asked you this question, and I'd like to bring that up. Ms. Federico, can you please move in hearing exhibit 304 from the association's box? And I'm scrolling down to 4-13. Thank you, right there. Oh, just past it. Right there. Mr. McAlpine, you are the sponsor of this discovery response. I'm assuming you did not mark each with a sponsor, but I assume these come from you. Is that correct?
I assume so. Yes, I'm the sponsor.
Your Honor, I'd like to move for admission of hearing exhibit 304.
Just want to give Mr. Davidson the opportunity. Any objection?
Well, there's more to it than just this one question and answer. Is the proposal to move the entire document or just this one Q&A?
Right now, it's just this one Q&A, Your Honor. This is just the way it was provided to us, so we are giving you what was provided.
I don't object to the admission of CVCA 4-13 and their response in exhibit 304.
Great. Okay. Exhibit 304 is admitted.
Thank you. If you could go down to your response here, when we asked you what was accurate, Mr. McAlpine, you said it was the normalization of operating expenses in the restated financials, correct?
Yes, that's what it says.
The extended period since the last rate adjustment, which we discussed previously, correct?
Yes.
And the revenue deficiency.
Demonstrated revenue deficiency necessary to sustain safe and reliable utility operations. Yes.
Okay. And thank you, Ms. Federico. You could take this down. And so the restated financials you mentioned, this is exhibit CLM 10, the LB&J Accountants report. Is that correct?
Yes.
Okay.
Your Honor, for the record, I think it's attachment CLM 10 to the rebuttal testimony exhibit 103.
I think you're right. Casey, does that sound right?
Yes, I have it as 103 attachment CLM 10 revision 1.
Okay, great. For purposes, you're welcome, Mr. Detsky. We'll know what you're talking about. Just thank you for the clarification, though. Thank you.
Thank you. It might be easier to call it CLM 10 for short as we move forward.
Yes, yeah.
Okay. Ms. Federico, can you pull up hearing exhibit 200 attachment DD-2 from staff's exhibits? And I'm looking at 1-5, which is, I believe, on the next page. Thank you. Right there is great. And so you had said that Mr. McAlpine, you testified just now that the cost and the revenue deficiency was a motivation for the rate increase. In this exhibit, staff asked you for basics of the revenue deficiency. And I want to first point you to sub B, where you said that operating expenses remain consistent with a small rural system. Do you see that?
There's two B's on the page. I'm sorry, I'm just looking.
I'm looking at your response. I apologize.
Operating expenses as reflected in the financials submitted as attachments to the direct testimony remain consistent with the small rural system. Yes.
What does that mean?
I don't understand your question.
I'm at, what does remain consistent with a small rural system mean in terms of your operating expenses?
We believe the operating expenses are consistent with a small rural system.
But you did not provide any detailed information as to what those are, correct?
I believe we did provide detailed expenses that we had.
Okay. Let's going down to sub C. When they asked you, the question was about all investments that Cascade has made into its water and wastewater systems since its purchase in 2021. And your response below was that it includes investments in engineering, PFAS compliance, CDPHE studies, right water engineers evaluations of the water and wastewater systems, legal mapping, and utility system improvements, correct?
That's what it says, yes.
So in terms of PFAS compliance, you testified that to date, the only expenses you've actually incurred are quarterly PFAS sampling. Is that correct?
No, I don't think that's correct. We've had a variety of consultants that have worked on that response and working on a different engineering system for what PFAS is asked for. I think there's a relocation of monitoring that's in a deep canyon, et cetera. There's a variety of work that's gone on around that compliance.
Ms. Federico, can you scroll down to the next page, 1-8, please? Right. Thank you, right there. Here, you were asked about the plans to comply, correct, with PFAS and PFOS standards, and your response was Cascade presently conducts PFAS sampling, correct?
That's part of the response, yes.
And then you said that Right Water Engineers is evaluating treatment options, correct?
Yes, that's part of
Okay.
the next sentence.
Thank you, Ms. Federico. You could take this one down. The association also asked for support on your operational expenses regarding staffing of Cascade. Do you recall that?
Not exactly, but I'm not arguing it.
Do you recall that you objected and refused to provide information on your staffing?
If that's what was in testimony, I'll believe you. I don't recall that particular line of dialogue.
Okay. Would it be helpful for you to see it to
Sure.
refresh your recollection? This is hearing exhibit 300, Ms. Federico, attachment WB2. And I'm sorry, I'm calling you Ms. Federico. Is it now Ms. Lynch?
Yes, but Miss Federico's fine.
Congratulations. I am at page 20. And 3-10, I'm sorry. Can you scroll down to capture 3-10? Does that refresh your recollection, Mr. Kalpine, that you refused to provide information on staffing?
Let's read 3-10 then. Please identify a number of staff Cascade has and the job description for each. And we answer Cascade objects to the request based on this is not likely to lead to the production of admissible evidence.
Does that refresh your recollection on this?
Vaguely.
Okay. Can you scroll up to page 3 of this document at question 1-19, Ms. Lynch? Thank you. Oh, you just passed it. There it is. Cascade also asked you about the line item expense of $82,000 in legal expenses from 2022. Do you recall this question?
Not really. There were a lot of questions, so I don't remember.
Okay, well, that's okay. That's why I have it pulled up. It says, you responded that legal expenses relate to compliance and environmental issues. Do you see that?
I do.
What were those compliance and environmental issues in 2022?
I don't recall sitting here today. I'd have to go and check the books and the invoices.
Okay. We could take this down, Ms. Lynch. In your rebuttal testimony, you present this Right Water, I'll call WWE report as part of your support for your rate increase. Isn't that correct?
That's correct.
Now, the Right Water report says that it used the operating expenses from the profit and loss statements that you provided to it, correct?
I'll take for granted that's what the report says, so I'm not looking at it.
Well, the Right Water report didn't review or analyze whether your operating expenses that you gave them were accurate. Is that correct?
I was not in the room when they did their work product for the work report, so I don't know.
Okay. The Right Water report is a rate projection that took your operating expenses and your rate increase and also plugged in its estimates of the upgrades to the wastewater treatment plant that it had submitted another report that were required. Is that correct?
Yes, I think the report speaks for itself.
Okay. So the Right Water report, in terms of your operating expenses and your revenue deficiency, is only as good as the data that Cascade provided to it for its cost of service, correct?
Again, I think these might be questions better asked of Brightwater, but I think they looked at a variety of factors.
Well,
Again, I did not produce that report. Brightwater did.
well, you did not present any witness from Right Water, isn't that correct?
I'd have to turn that to Mark.
So we don't have any testimony as to what Whitewater did or didn't look at. Isn't that correct?
Are you asking me or
I'm asking you.
uh, we have what's in the record? Again, I don't speak to Whitewater. I take their report based on them being an industry leader in this.
So if Whitewater said that we just used the profit and loss statements that you gave them, then if we're trusting them, that means that what they used is only as good as what you gave them. Isn't that correct?
Again, if that's what they said.
Do you acknowledge that in this application that Cascade has put forward at least three different costs of service via different profit and loss statements and balance sheets over the 3-year period of 2022 to 2025?
I acknowledge that there was one report that was submitted that was not reviewed by the accountants, and when it was reviewed, the accountant said this is not proper GAAP, generally accepted accounting practice, and that's why the second report was done. Possibly there was an earlier third. I don't recall that.
Well, that you presented one set of profit and loss. You actually presented two sets of profit and loss statements and balance sheets in attachment 4 to the application, correct?
If that's what attachment 4 of the application is, then yes. Again, I'm not looking at that.
Okay, you presented a second profit and loss statement in discovery when you provided the LB&J accountant reports to Cascade and to staff, or to the association and to staff, correct?
Yeah, we did submit the LBJ, which is what we believe to be accurate. I think some earlier miscommunication of what was to be presented.
And then you presented a third profit and loss statement, or fourth now, sorry, when you presented a different LB&J report in rebuttal testimony than what you had given to the association a month earlier. Isn't that correct?
If that's what the record reflects, yes, we relied on both counsel and the accounting firm to provide those. I don't know
Okay.
if that's restated.
Ms. Lynch, can we please turn to what is WB-6, please? Hearing exhibit 300. And can you scroll down to the profit and loss statement? Thank you. And I'm going down to, I want to go down to accounts receivable. Right there. Thank you. Do you see here, Mr. McAlpine, on the total for accounts receivable line, $0?
I see that on the page.
Okay. And Ms. Lynch, can you please go up to the first page? To page 1, sorry. Just want to point out that this is the LB&J memorandum dated February 13th, 2026. Is that correct, Mr. McAlpine?
Yes, that's what it says.
Okay. Now can we please open CLM 10? Same letter from LB&J dated February 13th, 2026, correct, Mr. McAlpine?
That is the date on the page it's showing.
Okay, can we go down to that same accounts receivable line? Right there, thank you. You now have different numbers in accounts receivable than 0, isn't that correct?
They are different numbers. It's two reports submitted on the same day, so it seems like the first one may have been submitted in error before it was complete.
So you're saying that LB&J accountants produced two different profit and loss and balance sheets dated the same day, provided within a month of each other to the commission. Is that correct?
But it looks like both were on the same day, and my speculation is that one was a draft and that it got somehow submitted in error.
Okay. Last Friday, or Thursday, I'm sorry, you could take this down for the moment, Miss Lynch. We were just discussing earlier CLM 5. And I would like to pull that up from the association's box. And let me see where I've marked that. Or what I'm sorry, I think we should just pull it up from, oh, here it is. I apologize. It is hearing exhibit 306, Ms. Lynch. Mr. McAlpine, this is what Cascade had filed on Thursday as attachment CLM 5, correct?
I was out of the country. I think it's probably a better question for Mark Davidson, but it does sound like something was submitted last week.
Well, Mr. Davidson is not a witness.
Okay.
So I would like to move for the admission of attachment CLM 5 on the basis that it was filed by Cascade last Thursday, that we discussed it earlier today, and that it is another profit and loss statement from Cascade.
Mr. Davidson, do you have anything to add?
No objection, Your Honor.
Great. Okay, thank you. 306 is admitted.
And thank you. At this time, Your Honor, I'd like to pull up the demonstrative exhibit that I prepared, which is hearing exhibit 305.
Great, thank you.
Thank you. First, I'd like to go down to the page 2, which is labeled Table 1. In this table, Mr. McAlpine, what I've done is taken the two LB&J reports that you submitted in this docket, one in discovery and one in your rebuttal, and I've compared the various discrepancies between the numbers. I'm not going to walk through this whole sheet with you. I just want to look at two lines. The first line I want to look at with you is the current liabilities. And so you say one was a draft and one was final. Do you see that, for example, in 2024, that there is about $500,000 to $600,000 of difference in the total for current liabilities between the two documents?
I've never seen this document before. So I'm just reading your numbers on the page, and it looks like, are you referring to the highlighted section and
I am. I'm referring
first
to the
box?
Sorry to talk over you. I'm referring to in this question, I'm referring to the far right column, 2024, the highlighted numbers.
Yeah, I see the numbers.
Okay, thank you. I would like to scroll down to table 2, Ms. Lynch. For this table, Your Honor, and Mr. McAlpine, This has the filed and withdrawn CLM5, which is here Exhibit 306. This has the attachment 4 to the application. And this has attachment 10, CLM 10. And it's comparing the two. And I just would like to show, for example, in the far right column, again, going down to looking at total for income, just to start off here. Do you see that each of these profit and loss statements has produced a different income amount?
I see that there's three different numbers.
Okay. Can you scroll down to the next page, rent? Do you see that you reported three different numbers for rent in each of these profit and loss statements?
I see that there's different numbers on the page. I would have to go back to LBJ to,
Yes, and I will say that you are welcome to check this and have your counsel go through it with you, but this is a demonstrative exhibit. All I have done is pull numbers from these various documents so we don't have to flip between them. But these are all in the record in the documents referenced. I will represent to you.
okay.
Thank you. You could take this down, Ms. Lynch. And these four documents, these four profit and loss statements that we've been going through, do you admit that not one of these agree with the last official sworn annual report that you provided to the commission in 2022 for this utility?
I think the documents that you just had up were for 23 and 24, right? So would they agree?
These were 2022, 2023, and 2024.
Again, I think it's a question for the accountants. I don't do the bookkeeping or final accounting, but I don't think it's abnormal that they would have restatements of accounting information.
But you submitted an affidavit and swore to the veracity of the numbers in the 2022 annual report, correct?
We filed the 2022 annual report as required, and we would have answered all the questions to the best of our knowledge.
Thank you. We'll return to that report soon. I want to talk about attachment CLM 10. The LB&J accountants, these accountants do work for CitySculpt. Is that correct?
They have done work for CitySculpt in the past.
And the accountant, Mr. Little, who signed the letter from LB&J, Mr. Little is not a utility regulatory economist, is he?
An economist? No, I think he's a certified public accountant.
Yes. But he is not an expert witness in utility rate cases on a regular basis, is he?
I don't know that answer.
Okay. I reviewed the LB&J website, and can we agree that the LB&J accountants are CPAs without any particular utility expertise?
I don't know what the firm's capacities are beyond the people that we deal with, but I think we hired them specifically for their accounting expertise.
Accounting expertise, yes. But the LB&J accountants are certified CPAs and therefore have similar qualifications to Mr. Bourquette, who filed testimony for the association. Isn't that correct?
Again, I think you're asking me, I'm not as familiar with Mr. Bourquette's experience or resume, nor do I know all the capacities of LB&J.
Well, do you hold LB&J accountants to be experts in utility accounting and rate making?
Not necessarily. It's not a question I ask of them.
Right, but you also criticize Mr. Bourquette for not being an expert in utility economy and rate making, but he has the same qualifications as LB&J accountants, isn't that correct?
Again, I'll leave that to council.
And in your rebuttal, you rely on LB&J accountants for their report of Cascade's profit and loss statements and balance sheets to support the rate increase. Isn't that correct?
We rely on LB&J for professional GAAP-based accounting.
Let's talk about that for a second. Because you testified that the LB&J, what they presented in rebuttal is that they have normalized, is the word you used, your accounting under GAAP. Is that correct?
Yes.
Okay. Now, GAAP is a standard of accounting reporting, but it's not a standard of verification or audits of accounting, is it?
Again, I think you'd have to ask that question to a professional CPA.
Ms. Federico, Ms. Lynch, can you please pull up hearing exhibit 308 from the association's box? Right there is fine. Do you see this response that you gave to CVCA 4-4 at the top?
Yes. Appears we.
Okay. So you admitted that these two reports were the same. Is that correct?
We admitted the answer to that question as stated.
Thank you. Do you recall that we also asked you in discovery whether or not that gap that, I'm sorry, let me back up again. Ms. Federico, can you scroll down to, on this page to 4-7? Oh, I'm sorry, it's on the next page. We will come back with that one. You can take this down. Can you please open attachment CLM 10, Ms. Federico? Thank you. I would like to scroll up to page 3, please. Right there. I would like to a little bit further down on the conclusion. Right there. Do you see that at the bottom here, Mr. Little wrote that I have not audited or reviewed the accompanying financial statements and accordingly do not express any opinion or any form of assurance on them.
I see that.
Okay. So it's true then that LB&J accountants did not verify Cascade's financial data. Isn't that correct?
Again, you're asking me what they did for their work product. That's one sentence out of that paragraph.
Yes,
all that seems appropriate and reasonable and consistent with GAAP accounting principles.
that's correct. I'm asking you, they say here, do they not, that they did not audit or review the accompanying financial statements. Do you see that?
That's correct. That's what it says.
And they also don't express any opinion or any form of assurance on them. Isn't that correct?
That's correct.
Okay, so that means that the LB&J report, like the WWE report we discussed, is only as good as the financial profit and loss statements that you gave them. Isn't that correct?
I think that would be correct with any work product. What data comes in is what produces a result.
Well, unless you had given them authority to audit and verify your records, then they would have gone into those records. Isn't that correct?
Actually, we've been seeking an audit firm, and LB&J does not do this type of audit. We are interviewing firms to audit Cascade New Ventures right now. But
That's great.
no one prior to these reports had performed an audit, and we didn't get any audit from the previous owners.
And you said Cascade New Ventures. What is that?
Well, I should say Grizzly Peak, and apparently I think they do have separate books, but we are attempting to audit this entity now, and we've had significant trouble finding a firm that would perform that audit.
Mr. McAlpine, earlier you testified that Grizzly Peak and Cascade do not have separate books. Isn't that correct?
Yeah, I think I was mistaken.
So they do have separate books.
They're separate entities. They would have separate books.
And which books and records are we looking at in this case? Those of Cascade or those of Grizzly Peak?
I believe they're a Cascade, but I think we'd have to talk to the bookkeeper.
And who is the bookkeeper?
Shayla Odom does bookkeeping services for the utility.
And is she a witness in this case?
I don't think so.
Okay. So all we have to go on then in this case is this report for which we have two different sets of numbers, and we have a statement that they did not audit or review anything underlying the numbers you gave them, correct?
That's their statement.
But you stated in discovery, or you stated in your rebuttal testimony, that you had an independent accounting firm restate the profit and loss statements, correct?
I'll take that for granted if that's what the rebuttal testimony said. I don't have it memorized.
Okay. And you stated in discovery that the LB&J report is your support for the operational costs and investments in your testimony. Isn't that correct?
LB&J would certainly be part of our support, but it wouldn't be the sole support.
Can you please, Ms. Lynch, open up hearing exhibit 309 from the association's box? And I'm looking at 4-12. Do you see this question in response? 4-12?
4-12. I just need to expand it a little. Documents supportive of the allocation of operating costs and investments in the system have been provided as an attached to the rebuttal testimony set forth in the LB&J financial restatement.
This is your response, correct?
Yes.
Your Honor, I'd like to move for the admission of hearing exhibit 309.
Sorry about that. I had trouble unmuting. Mr. Davidson.
Again, Your Honor, there's more to this document than just the question and answer Mr. Detsky has inquired about. If it's offered for only that question and answer, I have no objection, but not sure what the rest of it might say.
Okay, yes, I'll go ahead. Understood. I could give it the weight it's worth relative to the items that are not germane to this discussion, and I'll go ahead and admit exhibit 309.
Thank you. So in this discovery response, Mr. McAlpine, you state that when you were asked the documents that support the statement that all utility operational costs and investments have been properly allocated and accounted for by the utility, Your support for that statement is the LB&J report, correct?
I think I would echo what Mark Davidson just said. That is partial support. It's
Mr. Davidson did not say that, Mr. McAlpine. He was talking about the other questions on this page.
Are you referring to a specific? Could you re-ask your question? Maybe I didn't understand it.
Yes. When you were asked in this 412 to produce any documents that support your statements and rebuttal, that all utility operational costs and investments in the system have been properly allocated and accounted for by the utility, you responded, that support is the LB&J financial restatement, correct?
The documents supportive of the allocation of operating costs and investments in the system have been provided as an attachment in the rebuttal testimony set forth in the LB&J financial restatement.
Thank you. Ms. Frederick, Ms. Lynch, sorry, you can please take down this one. And please open hearing exhibit 331 from the box of the association.
I don't see a 331 in there right this second. Give me a minute to see if it is just not loading.
Okay, we'll come back to it. Apologies. So I would like to pull up hearing exhibit 310, Ms. Lynch.
Sorry, give me just a second. I was checking on the website too, because sometimes they get added there quicker. 331 is not in there. I'll bring up 310, but just letting you know there is no 331.
Thank you. Can you scroll down a little bit, Ms. Lynch? Right there. Do you see that this is the 2022 annual report for Grizzly Peak Water Sales and Distribution, Mr. McAlpine?
Sorry, I'm having to expand this.
Mr. McAlpine, I can make it larger if you need me to. Just let me know.
Can you go back to page 1 just so I can verify the cover page? Okay. Then we can go back to page 2. I'm sorry, what's the question?
I'm asking you if this is the 2022 annual report filed by Grizzly Peak Water and Sales Distribution with the Commission.
Yeah, it appears so.
Your Honor, I would like to move for admission of this exhibit 310 through administrative notice as a document in the Commission's files.
And Mr. Davidson, any objection?
No objection, Your Honor.
All right, admitted.
Thank you. Ms. Lynch, can we take this exhibit down and open up hearing exhibit 305? And I would like to go down to table 4, please. I'm sorry, table 3. Table 3, please. Your Honor, Mr. McAlpine, again, for the efficiency of the hearing, what I've done in this table 3 is I've taken the 2022 annual report, which we just admitted. I've now compared that against the other profit and loss statements that we talked about earlier. This is the attachment 4 to the application. This is also your rebuttal testimony on page 18, and this is CLM 10. Do you see those reflected here?
I'm sorry, is that a question for me?
Yes.
I see that. I've never seen this document before. I do see the table.
And I understand that. I'm giving you a chance. I want to give you time to look at it. This is, again, solely reporting numbers from these documents in one place so we don't have to flip between 4 documents.
Okay.
Okay. I want to first look at this amount owed to Citysculpt. Do you see that of the 3 of the annual report compared to the 3 profit and loss statements, 2 in attachment 4 and 1 in CLM 10, that only one of them listed any amounts owed to Cityscope?
I see your chart. Yes.
Thank you. Skipping down to projects in process. Do you see that there was no line item for projects in process in the 2022 annual report?
I see your chart. I don't know that the annual report called for that, but
Yes, and you can check with your counsel. This is all subject to your check. Do you see that there are different numbers? For example, 2022 project in process. There's different numbers in each of the profit and loss statements for projects in process.
I see the chart and that the numbers are different.
Thank you. Let's scroll down to the bottom here where it says rent on the next page. Do you see here that rent was not specified in exhibit in the annual report?
I see the chart. Yes.
We'll come back to that later on. I just want to note here, this is the $180,000 a year line versus 0 in attachment 4. Do you see that?
I see the 2 different numbers. Yes.
Okay, thank you. You could take this down, Ms. Lynch. So do you agree that this normalized accounting under GAAP in CLM 10, its entries do not reconcile with either the 2022 annual report or the profit and loss statements you filed with the application in attachment 4?
I saw that your chart had different numbers. Yes.
Okay. Ms. Lynch, I think I'm now ready for you. I apologize for the mix-up before on hearing exhibit 331. And I'm looking at 4-7. Right there in the middle of the page. Do you see here, Mr. McAlpine, that you were asked whether GAAP is an accounting practice and not a verification of the underlying accounting data?
4-7. Is that what you're asking me? I'm sorry.
Yes, I am. Thank you.
Please refer to page 18, line 810 of the rebuttal testimony, which states the company conducted a financial review with LB&J CPA in Charlotte, North Carolina, and restated financial statements based on GAAP to properly reflect operating expenses. And then please admit that GAAP accounting practice is not a verification of the underlying accounting. And the response was that that was admitted.
Yes, thank you. Your Honor, I'd like to move for the admission of hearing exhibit 331.
Mr. Davidson, any objection?
Well, same comment as before, Your Honor, just limiting the admission to this one question and answer.
Yes, okay, understood. So I'll go ahead and admit it. Thank you.
Thank you. Ms. Lynch, can you please open up hearing exhibit 103, the rebuttal testimony, Mr. McAlpine, at page 18? Thank you. Can you scroll down to starting at line 11 and all the way to the bottom? Yes, thank you. Right there is perfect. Mr. McAlpine, I want to talk to you about this category you call projects in process. And here in your rebuttal testimony, you discussed projects in process that were recorded on the balance sheet. Is that correct?
Yes, I'll let the statement speak for itself.
And I want to look at the line 19 where you have an asterisk and say projects in process. I just want to make a correction here. Those three numbers, 2022, 23, 24, I get 249, 359, and not 349. Do you agree?
It does look like there's a math error.
Okay. Subject to check, will you accept that those add up to 249 and not 349?
Yes.
Okay. So the individual columns in this chart do not have a total row, but when I add up the totals using 249, I'm getting $1 million roughly on these three expenses that you say are normalized operating expenses. Do you agree with that? Subject to check?
Yes.
Thank you. This footnote where you say PIP balances consist of engineering, feasibility, planning, legal, and costs associated with maintaining the utility up to CPUC regulations. Do you see that?
Yes.
Okay, so let's take that apart a little bit if we can. You say legal, but when I look in legal, I see the 249, and I'm looking at CLM 10, which we can flip to if you would like. But in addition to $249,000 under legal, I see another column for professional fees, legal, of $100,012, $112,312. Do you recall that?
No, we may need to flip to it, but I don't typically recall line items like that.
Okay. Can we open CLM-4 or attachment 4? CLM-4 is also what it's been called. I think it's 102 dash
I
attachment
was
4.
gonna say, I think it's now, Mr.
102.
Davidson, to me, 102 attachment 4.
Yes.
Okay.
And page 6, please. Okay. I'm looking at professional legal, and I see a total right there of $112,000, $112,312. Do you see that line?
I do.
Okay. So you have legal expenses, and then you have legal expenses that are within the projects in process in your table in your rebuttal. Isn't that correct?
I'll assume that's correct. I'm not sure how bookkeeping created the line item entries.
Okay. You could take this down, Ms. Lynch. So the legal expenses, these are entries that are since you've acquired this utility, right? Since 2021, correct?
Correct.
And the only cases that I'm aware of that Cascade has had with the Public Utilities Commission in those 3 years is this one and the application you withdrew last year. Isn't that correct?
The only cases, yes, but that wouldn't be the sum of legal expenses.
Understood. But these legal costs, these are not PUC proceeding costs, correct?
Some of them are, I assume, and some of them are not.
Well, the only cases you filed were in 2025, and these are expenses from 2022, 23, and 24, then these weren't for PUC cases, correct?
The original filing expenses would have been in there when they were filed, but more importantly, legal expenses on water rights and easements, et cetera, would fall into that.
I see. Now, turning back to that footnote, you also have costs associated with maintaining the utility in the projects in process. I want to look at CLM 10, please. Can we pull up that, Ms. Lynch?
Yes, sorry, just taking me a second to find it.
Yes, no problem. Page 4. Can you scroll down a little bit on this page 4? So here I see you have maintenance, waste, and maintenance water. Do you see that?
I'm looking for it. Yes, I do.
Okay. So you also have maintenance in a separate category from projects in process. Isn't that correct?
Again, I'm not sure how the bookkeeping itemizes this, but I see the two line items for maintenance waste and maintenance water.
Okay. Now, staying on this CLM 10, can you scroll down, sorry, to page 5, Ms. Federico? Right there. When you look at, I see projects in process here, Grizzly Peak. Do you see that?
Give me just a second. Yes, I see that line.
Okay. Do you see those numbers of 208,000, 289,000, 358,000?
I do.
Okay. Those numbers, they don't match the 249,000 that we discussed in your rebuttal that you listed for projects in process, correct?
I think again, I'm expecting there's some accounting restatement to be done.
Okay. Well, let's go up in this exhibit, Ms. Federico, up to page 2. Thank you. And can you scroll down this page? Right there. Do you see this B, projects in process expenses, Mr. McAlpine?
I see that label in the paragraph, yes.
Okay. Do you see where it says a portion of these projects did not advance to construction, were deferred indefinitely or otherwise abandoned? Do you see that?
I see that statement, yes.
Okay. And the adjustment there, those numbers, do you see them?
I see the numbers, yeah.
Okay. Now, I can go back to your rebuttal if you need, but I want subject to check. Those add up to the same $249,000 that you put forward in your rebuttal testimony as projects in process. Does that ring a bell?
Your question is that the math or?
My question is, are those the same numbers that you put forward in your rebuttal testimony at page 18 as projects in process?
Can we pull up my rebuttal testimony at page 18?
Yes. Right there, the project in process line.
Yeah, those are the same numbers. As you pointed out earlier, it looks like there was a mathematical clerical error.
Yes. So here's my question. Why did the LB&J report say that those projects in process were abandoned?
I think that's a general accounting statement.
What is the accounting statement?
Well, let's go back to the other. It's an LBJ document. Let's go back to that we just had up.
CLM 10.
CLM 10. Yes, thank you. Right there. No, you had it. Portion of these projects did not advance to construction. Do you see that?
I do.
What projects did not advance to construction?
Well, there's a variety related to Grizzly Peak. There's relocation of monitoring devices. There is upgrades to the facility, which we can't afford right now. There's future upgrades and plans that whether or not we're required to connect or upgrade our system to other things, there's a variety of things there. I don't know why. You'd have to ask LBJ why they categorize these that way.
Well, LB&J said that they didn't verify anything. They just used what you told them. So this is your telling LBJ that these projects did not advance. Isn't that correct?
No, I don't believe that's correct. I don't know where this statement came from, and I don't know what projects they're referring to specifically.
Have you abandoned any projects?
Grizzly Peak has a variety of things that are working forward that may advance one day, but it is unknown when they'll advance at this point.
But this is looking backwards, isn't it? It's 2022, 23, 24. It's not looking forwards. These are projects that your accountants here, the report that you rely on for your case, is saying that these projects have been abandoned, totaling $249,000. What were they?
Again, as the LBJ said themselves, they did not audit the entire system. They may have put things in this category that may move forward in the future. For projects that were abandoned in those timeframes, I'd have to go back and look at all the activities we had related from 21 when this utility was bought, and we had to restructure all of the books.
Well,
We had to talk to the state regulators who in some cases hadn't been spoken with in a decade. And they said, oh, great that you called. You have all these things that you need to work on. And we've been one by one working our way through those things for the past 6 years.
and what are those things?
Again, I'd have to go back. I don't have the memory of that right now. I'd have to go back and look at what we were working on at the time.
Which state regulators are you talking about?
Well, I can't name the agencies. The acronyms sometimes confuse me, but we rely heavily on Brightwater to help us work our way through that, as well as trying to make the annual reports to the best that we can, et cetera. It does look like some need to be restated, but all the regulatory agencies that would regulate a public utility for water and sewer.
Okay, now that is the Colorado Public Utilities Commission, isn't it?
Yes, we also have sort of an environmental side of that as well that we're dealing with.
So do you see up here that LB&J reported that projects in process consisted of preliminary engineering, feasibility, planning, legal, and development costs associated with maintaining the utility up to date with CPUC regulations? That's the commission, is it not?
Yes,
It also says this includes engineering, legal costs associated with researching special district designation. Do you see that?
yes.
What have you abandoned regarding special district designation? What have you abandoned regarding maintaining the utility up to date with CPUC regulations?
Again, I'd have to go back and look at our line item costs to see if we've actually abandoned anything. I think LB&J may be under the impression that we abandoned special district designation, which we have not. We did stall that process because we couldn't afford to take it forward until recently. So those are the types of things that popped to mind, but I don't have a list of specific abandoned projects to share with you.
Okay, thank you. You can take this down, Ms. Lynch. I want to talk to you about, I have two more topics here in this part one of my cross, Your Honor, and then I would be at a place for a break. Or we could take a break now if you would prefer.
Mr. Davidson, do you have a preference?
Depends on how long Mr. Detsky's remaining questions in phase one might be. Otherwise, now is a fine time to take a break as far as I'm concerned. We've been at it for an hour and a half or so.
And Mr. Larson, do you have a preference?
No preference from staff.
How about this? Why don't we take, is 10 minutes good for everyone right now? And then we can resume. Okay, let's take a break until 11:10 and then we'll go back on the record. Thank you.
Thank you, Your Honor.
Tracy, are you ready to go?
Yes, I am.
Great. Okay, let's go back on the record and Mr. Detsky, go ahead and do we have everyone here? Let me just make sure. Does not appear Mr. McAlpine or Mr. Davidson are with us, so let's hang out another minute and see if they join.
I'm here, Your Honor. I
Okay.
had a hard time getting my camera going. Sorry
Yeah.
about that.
Understood.
I'm
All
here.
right. Great. Okay, go ahead and proceed. Thank you.
Ms. Lynch, can you open 103, the rebuttal of Mr. McAlpine, Rev 1 at page 15, line 20? Okay. Thank you. Now, here we were talking about the annual cost adjustment that you have chosen. And you state here at line 21 of this testimony that it would be speculative to assume what, if any, growth comes onto the utility system. Do you see that line?
Do.
Now, under this annual cost adjustment,
I'm sorry, can we clarify what document we're looking at? I apologize.
sorry, we're looking at your rebuttal testimony.
Okay, thank you.
And this annual cost adjustment, I want to talk to you about how it would work when you add new customers. You have 160 customers now, and if this rate increase were to be approved, the rates would be roughly $200 a customer per month, correct? $199.
I believe that's right.
Okay. So if you have 160 customers and they're each paying $200 a month, hypothetically, I get a number of a revenue to the utility of about $384,000. Does that seem right to you?
Yeah, let's just check the math to be sure, but it sounds right.
So if you're approved to earn that revenue and have that revenue increase at the formula set forth for the adjustment, and then you add customers, wouldn't that have the effect of giving the utility more revenue than it's approved to earn?
I don't think so.
Well, let's say you add an additional customer, and that customer is paying $200 a month or $2,400 a year. If you're approved to earn $384,000, and then you add $2,400 to that total, then you are at a number that you are not approved to earn in this case. Isn't that correct?
I don't think that's accurate. I think additional users coming onto the system spread the cost of what will be future demanded expansion, or expansion is probably the right word, of the system. We've been put on notice by the state of Colorado that we have to do something about the current lagoon system.
And I understand that. And what I'm asking you, though, is under this annual adjustment that you've chosen, there's going to be a formula that increases your revenue each year. Isn't that correct?
Yes, we work off the regulated formulas.
Right. So if that formula is based on a certain number of customers and then you add customers, then you're not spreading that amount over more customers. You're just adding more dollars to your total. Isn't that correct?
No, that's incorrect. There's an incremental cost to adding customers and to service those customers, as
Yes.
well as planning for the future of the utility.
But isn't the annual cost adjustment formula meant to handle that incremental cost? Isn't that the purpose?
I don't know the answer to that.
Okay. The WWE report that you submitted as CLM 9 this one that looked at the future costs we talked about before. Do you recall that the WWE report had an assumption that Cascade would add one customer per year over 30 years?
No, I don't recall that.
Okay. Can we please open hearing exhibit 311 from the association's box? And I'm looking at 4-5 here in the middle of the page.
Is this the WWE report? Oh,
No, this is the discovery that we asked you.
okay,
Do you see this discovery 4-5 in your response?
I do.
Okay. I want to move for the admission of hearing exhibit 311.
Any objection from the parties?
My same comment, Your Honor, with respect to the other versions of these questions. Thank you.
Okay, admitted. Thank you.
Do you see your response here to question C?
I do. What is the basis for the assumption of one tab per year being added? Yes, I do.
Okay, thank you.
I would say there's no assurance that sitting here today that there'll ever be any new customers added.
Let's talk about that. Can you please take this down, Ms. Lynch? And can you pull up hearing exhibit 312 from the association's box? Mr. McAlpine, in discovery, you admitted that an entity called Cascade Meadows has submitted plans to San Juan County to develop lots that you own next to the association's property within the service territory of Cascade, correct?
Cascade Meadows LLC owns a parcel of land that they are seeking approval of lots. Yes.
Okay. And in discovery, you discussed that when we asked you about property to be developed, and you said up to 144 new units would be developed on the property you own. Isn't that correct?
That's a possibility. Yes.
Okay. What I have here, Your Honor, up as Exhibit 312 is the Board of Commissioners meeting agenda and packet from San Juan County, Colorado from April 8th of this month, where the Cascade Meadows subdivision proposal was considered by the Board of County Commissioners. I would like to move the admission of this document as under administrative notice. But I would also like to ask Mr. McAlpine if he is familiar with this document where he is mentioned and has various documents bearing his name in the application packet.
I'm familiar with the application packet.
Wait a minute,
yes.
wait. Your Honor.
Do either of the parties have any objection to this?
No, I object, Your Honor. I haven't seen this before this moment. And I think Mr. McAlpine said that Cascade Meadows is a different entity from the applicant in this proceeding. So again, I just don't know what the what's in here, first of all, and secondly, what its applicability is to this proceeding. So I think maybe it's irrelevant to what we're doing here.
Okay, Mr. Detsky, do you mind just doing a quick offer of proof here so we have a sense of what this is for?
Yes. Mr. McAlpine just talked about how there's no guarantee that there would be any additional customers added to the system. He also, and we could show this in discovery, stated that he was the developer, or Cascade was related to the developer of this property. Cascade is mentioned in this document numerous times, and that's why I'm offering it, is to discuss the expansion of the Cascade system and how Cascade utility was discussed and presented in this application. I can give you the page numbers that I will limit the administrative notice to, if that would be helpful.
And Mr. Davidson, did you have a response to that?
I think at a minimum, it would need to be limited to the page numbers that Mr. Deskey just offered to limit this to. Again, this refers to, at least as I look at this front page, Cascade Meadows preliminary subdivision application. There's a whole bunch of other new business reflected here. So I think there's a lot of material in here that's irrelevant to this proceeding, Your Honor, based upon just what I'm looking at on the screen.
Sure, understood. Okay, yes, why don't we go ahead and I will admit this, but with the understanding that the items that have no relationship on any level to this proceeding will not be evaluated. So go ahead and proceed, Ms.
Thank you, Your Honor. Can we please turn to page 15 of this document? I'm looking at the middle of the page, Mr. McAlpine, and it says the applicant plans to construct 72 units on tract A1 and B1 of Cascade Village subdivision. Do you see that?
I see that paragraph.
Okay. So wouldn't it be a reasonable assumption that instead of one customer being added per year over 30 years, wouldn't it be more reasonable to assume that 72 customers would be added at least during that time, hopefully sooner?
No, I don't think so. I think the rate case that we have in front of us now is a normalization of rates for the customer base that we have today with the cost that we have today. This is a preliminary subdivision filing, which would give the allowance to build a road, but it doesn't sell the units. It doesn't move anybody in. There's a variety of things that may happen. As far as I know, there's no financing to support this. There is a variety of things that have to happen for any new residents to move in.
Yes. And do you think that 30 years would be enough time to have new residents move in?
I would hope so, but we can't take that as a given.
But in terms of the assumptions that you're making in this WWE report of 30 customers over 30 years, wouldn't 72 be more accurate given the plans to develop the property?
Well, I don't think so. You're looking forward of what may happen. We could also look in reverse of what has happened. If we have 160 units now and Cascade's original subdivision plan was approved in, I'm trying to remember the date, 1990 something.
Well, no, I appreciate that.
The
I appreciate that.
absorption has
Talking over you.
not been robust. And again, there's no assurance that this or any other things will ever be built in Cascade. The only thing that we know for sure is that the state has mandated that we rebuild the system.
The state has mandated that you rebuild the system?
Of the sewer utility plant, yes.
The state has mandated that you rebuild the utility plant, the wastewater treatment plant, you're saying?
Yes.
Okay. I've not seen that anywhere in this case before. Is there something in WWE report or elsewhere that says you're mandated to rebuild the treatment plant?
I think you have seen it. The WWE report that we requested where they compared the cost of upgrading, which is what I mean by the rebuild, the current system versus the cost of connecting to Cascade, which is part of an evaluation that we're considering for long term. We know that one of those two things has to happen, regardless of getting any new users whatsoever.
I want to look further down on this page where it says Mr. David Marza. Do you see that line?
Yes.
It says Mr. David Marza of Grizzly Peak Water Sales and Distribution has provided a letter saying that Grizzly Peaks has the capacity to provide water and sewer service for 72 new residential units. Do you see that?
Yes.
Okay. So let's just hypothetically assume if 72 customers were to join the system as compared to 30, that's quite a difference in your revenue assumptions on tap fees, isn't it?
Yes, but you're only looking at one side. You've not made the assumptions on expenses related to those 72. But
Right, I'm just looking at the
you've made
tap fees.
assumptions of what may happen in the future.
Now, your tap fee proposal, what are the tap fees to be used for?
Connections, service fees for new users.
You stated in discovery that you also might want to use the tap fees to repay loans for Cascade. Isn't that correct?
Yeah, at some point, Cascade has a variety of loans it has to repay.
So if the tap fees were used to pay loans, that money would not be available to pay for wastewater treatment plant upgrades. Isn't that correct?
Yeah, but you're taking a broad leap. That accounting has not been designated of where the tap fee revenue would go, or, and again, that there's any tap fee revenue to come whatsoever.
And your tariff that you have on file with the commission, that requires new customers to pay for their own service line extensions and service drops, correct?
It might be I believe that's correct.
And that's in addition to the tap fee, correct?
Yes.
Okay. In your rebuttal, you state that Cascade might need to come back to the commission for permission to include the additional wastewater treatment plant investments in the company's rate base. Do you recall saying that?
Not specifically, but I'll assume that that's read from my rebuttal.
Do you commit here to return to the commission for any approval of an upgrade to the wastewater treatment plant facility?
I think we commit to follow any of the guidelines that we're given. We're trying to do our best to follow those.
Okay. I want to talk to you just briefly about the Major Capital Improvements Fund. You testify that the Major Capital Improvements Fund will be used to pay for some of these upgrades that are needed to the wastewater treatment plant. Isn't that correct?
I believe that's accurate.
And your testimony is also that the capital upgrades to the wastewater treatment plant is a driver of your need for a rate increase generally. Isn't that correct?
I'm sorry, can you restate that?
Your testimony is also that the capital upgrades that the wastewater treatment plant needs is a driver for the overall rate increase here. Isn't that correct?
Well, no, I think they are related, but they're somewhat separate. They're the utility as it is, if it never needed to expand, does not generate enough revenue to cover expenses. If it expands, then that gets worse, which is where typically I think a utility might have a.
So I'm not sure I understood. Are you saying that the upgrades to
capital
the
improvements.
wastewater treatment plant are part of your rate increase generally or not?
No.
No. Okay, thank you. That concludes part one, Your Honor, of this cross. And now I'd like to switch gears to part two and talk about the loans and the Cascades affiliate transactions. And we're going to talk about some of these affiliate entities that we've already mentioned so far. I wanted to first start and talk about CitySculpt LLC. You own 90% of CitySculpt LLC, is that correct?
I own a percentage of CitySculpt LLC, yes.
Is it 90?
I'd have to look at our cap table right now.
Okay. Can we please open hearing exhibit 326, Ms. Lynch? From the association's box, sorry. And I'm looking at 4-8 on this page. And scroll down if you can capture the response. Let's stop here so we can see the question on A. Can you scroll a little bit higher, please? Do you see where you were asked, does Mr. McAlpine own or has he ever had an ownership interest in CitySculpt Colorado LLC? Do you see that?
Yes.
Okay, can you now scroll down, Ms. Lynch? to the response to A? Do you see where you say you own approximately 90% of City Sculpt?
Yes.
Thank you. You could take this down, Ms. Federico. Ms. Lynch. Okay. And do you admit that you own or control Cascade?
No.
City Sculpt is the member of the Cascade LLC, isn't that correct?
The Cascade LLC.
Is the member of the LLC, Cascade New Vision.
City Sculpt is the manager hired by that entity.
Your Honor, for this impeachment, I'm going to need to open up the confidential purchase and sale agreement attachment WB3C. I think the webcast might need to be turned off, but I believe that everyone here has an NDA or doesn't need one.
Okay, I am unmuted. Casey, are you able to get us into confidential session at this time? And just heads up to the other parties that I do just want to do this once. So we'll do a little, as I noted before, it might make questioning not as continuous, orderly as you would like, but we're going to do all of this in one session if possible. So why don't we go ahead and actually, Casey, can you help facilitate this and let me know what I need to do?
Nothing. I'll do it all. I'll just
Okay.
need a couple of minutes. It's more than
Of
just
course.
so I'll let you know when we're all set.
Great,
Okay.
thank you.
And I will try to ask some questions out of order to make that happen.
Thank you.
Have to listen to make sure we're back because of the delay. So it'll be about another minute.
Thank you.
All right, we are back.
Thank you. So if anybody is joining us, we just did a confidential session and now we are back in regular session. And Mr. Detsky was going to continue his cross-examination.
Thank you, Your Honor. Mr. McAlpine, do you admit that you own or control Cascade Meadows LLC?
I do not.
Does City Sculpt own or control LLC? Is Cascade Meadows LLC?
It does not.
Do you admit that you are the registered agent for Cascade Meadows LLC?
I do. I do.
You do. Do you admit that, well, let's go to hearing exhibit 300 WB2. Ms. Federico, can we pull up WB2 at page 9? Thank you. I'm looking here at 126. And can you please look at that? Let me know when you've read it.
I've read it.
Do you see here that you admitted that you do own additional property that the Cascade system is designed to serve in the future?
We own portions of.
Portions of, okay. Can you please scroll up to page 5 of this document, Ms. Lynch? Looking at 1-27, can you scroll down a little bit to capture that? Thank you. Here you were also asked if Cascade New Vision has proposed a development of properties that would be served by Cascade New Vision to San Juan County. Do you see that?
Please admit that the owner of Cascade New Vision has proposed development of properties that would be served by Cascade New Vision to San Juan County.
And you responded that yes, only the Cascade Meadows parcel has submitted plans to San Juan County. Isn't that correct?
You added the yes. It says only the Cascade Meadows parcel has been submitted to Cascade to San Juan County.
Well, I added yes because this question was asking for your admission. Isn't that correct?
I'm just reading as it's stated.
Yes. You also admitted here that a road extension has been approved for the owner of Cascade New Vision. Isn't that correct?
For the Cascade Meadows LLC, yes.
And you also said that Cascade Meadows intends to submit further plans for approximately 144 duplex units. Do you see that?
That is what it says.
Okay, so here you are testifying that you know of Cascade Meadows, its submitted plans, its approved plans, and its future plans for development. Isn't that correct?
I'm admitting that Cascade Meadows submitted at the time of this document, it had submitted and been approved for the road extension, and it subsequently submitted for approval for the future building of 144 duplexes. Yes.
Correct. Thank you. You can take this down, Ms. Lynch. Mr. McAlpine, do you admit that you own or control Cascade Hospitality LLC?
I do not.
Do you admit that you are the registered agent for Cascade Hospitality LLC?
I believe I am.
Okay. Does City Sculpt own or control Cascade Hospitality LLC?
Does not.
Do you admit that you
May own a portion. I want to make sure that I'm accurate.
may own a portion, you say?
I'd have to check the cap table, but it wouldn't be, City Sculpt could own a fraction of that LLC.
Okay.
Not a controlling fraction.
Do you admit that you own or control Moorhead Property One LLC?
I do not.
The registered agent for Moorhead Property One is City Sculpt, isn't that correct?
I'd have to check the records.
Can we check the records by uploading hearing exhibit 316, please, from the association's box? Mr. McAlpine, do you see that this is a statement of foreign entity authority from the Colorado Secretary of State?
I do.
Do you see this is for Moorhead Property One LLC?
I do.
Okay. Scrolling down, please, Ms. Federico. Do you see here? Oh, sorry. Right. Oh, just passed it. Do you see the registered agent is City Sculpt LLC?
I do.
Your Honor, I'd like to move for the admission of hearing exhibit 316.
Any objections from the parties?
No objection, Your Honor.
Great, I'll admit it. Thank you.
Thank you. Mr. McAlpine, after City Sculpt entered into the purchase and sale agreement we looked at before in 2021, you can take this down, Ms. Federico, I'm sorry. After City Sculpt entered into that purchase and sale agreement for 44 acres of land, City Sculpt then assigned that agreement to Moorhead Property One. Isn't that correct?
That sounds accurate.
Thank you. Can we please pull up what is attachment 1 to hearing exhibit 102? Oh, sorry. maybe it's attachment A to 102. It's the WWE report.
There's no A's. There's just 1, 2, 3, and 4.
Are you talking about the March W, the March report?
Yes.
Is that CLM 10?
No, CLM 10.
I believe it's attachment 3, just for clarification of the record, attachment 3 to the application. I could be wrong, but that's my.
Yes, attachment 3. Thank you.
That's correct, yes.
My apologies. Attachment 3 to 102. Thank you.
My apologies.
Thank you. I just want to focus here on this letter from Right Water from October 5th, 2023. It's addressed to Michael Miller. Isn't that correct?
Yes.
And here Michael Miller is listed as CFO of Grizzly Peak Water Sales and Distribution. Isn't that correct?
Yes, but that would not be his title.
Well, that's what it says, isn't it?
It's from Right Water Engineering, so they may have made a misstatement.
Okay. Thank you. You could take this down, Ms. Lynch. I would like to pull up hearing exhibit 300, attachment WB4, please. And this document, this is the closing documents from that transaction that we just saw the purchase and sale agreement on that was filed with Mr. Borquette's testimony. Do you see how
Sorry.
Do you see the special warranty deed was made between Grizzly Peak Investments and Moorhead Property One LLC?
I do.
Okay. Can you please scroll to page 28 of this document? And this is the purchaser's affidavit at closing. Do you see that, Mr. McAlpine?
I do.
Can you scroll down to the bottom of this page? Thank you. Do you see that Michael Miller signed this affidavit, Mr. McAlpine?
I do.
Do you see it says member of Moorhead, manager, sorry, of Moorhead Property One?
I see he signed as manager.
Of Moorhead Property One, correct?
Yes.
Okay. Can you please go up to page 26 of this document? This is an addendum to the closing instructions of the same closing. And I want to look at the last paragraph of this addendum. It says that buyer and seller agree that the 100% membership interest will be included in this transaction. The purchase price of $150,000 will be received from Cascade New Vision, an affiliate of buyer, and dispersed to Grizzly Peak Water Sales and Distribution, LLC, an affiliate of seller. Do you see that?
I do.
Okay. So the buyer here was Moorhead Property One, correct?
It seems so, yeah.
Yeah. And so the buyer, who is the affiliate of Cascade, signed this document, and the signature is, again, Michael Miller as manager of Moorhead Property One. Isn't that correct?
I see his signature.
Okay. Can we go up to page 8 of this document, please? This is the settlement statement from that closing. Isn't that correct, Mr. McAlpine?
Wasn't this supposed to be in confidential testimony?
This was not declared confidential, no.
I see it's a closing statement.
Okay. If we can zoom here at this first top number, do you see contract sales price $1.5 million?
I do.
Can we scroll to the bottom of this document? Second to last line, it says 100% membership interest in water company to Grizzly Peak Water Sales and Distribution, 150,000. Do you see that?
I do.
Okay, can you scroll to the next page, please? Do you see that Michael Miller approved and accepted this document?
I do.
Can you scroll to the next page, please? And so this was also attested to by an escrow corporation, correct?
Yes.
Can you scroll to the next page, please? And I think one more page, I apologize. Oh, one more page, I'm sorry. Try and find. Oh, we can return to that. You can put this document down. CVCA, or the association, asked in discovery about Michael Miller, who signed this affidavit, as well as someone else named Mr. Thomas Jordan. And you responded that these individuals have provided services across entities under common management. Isn't that correct?
Sorry, are you there? Can anyone hear me?
We can hear you. You look frozen on my screen. Oh, there you are. Can you hear me?
I can hear you now. Could you restate your question? It cut off.
Yes. The association asked in discovery about Michael Miller, who signed this affidavit, as well as the other closing documents, as well as another individual named Mr. Thomas Jordan. And you responded that these individuals have provided services across entities under common management. Isn't that correct?
That's my response, yes.
So Michael Miller, yourself, City Sculpt, these are all affiliate companies of Morehead Property One and Cascade Meadows, as well as Cascade New Vision and Grizzly Peak. Isn't that correct?
That question didn't make any sense. Could you restate?
Yes, the common management of where we saw Mr. Miller and we see City Sculpt appearing in multiple places. The common management of these companies makes these companies all affiliates, correct? And I'm talking with companies, I'm talking about our City Sculpt, Cascade, Morehead Property One, Cascade Meadows. Isn't that correct?
No.
Okay. I want to pull up hearing exhibit 300. Attachment WB5. And if you could go to page 4. And if you could please zoom in on that map. Now, could you zoom in even further, Ms. Lynch? I'm trying to see some pretty small writing on it. Thank you. And this is small, but this map visualizes what we've seen in the purchase and sale and closing. And I want to point out a few things. First, you see in the upper left, tract A1, where Cascade Meadows LLC is written on it.
Yes.
And do you see tract B1, where Cascade Hospitality LLC is written on it?
Yes.
Okay, those track to the purchase and sale agreement and to the San Juan County Commissioner's development application, correct?
They track the
Those
tracks.
are the same. Those are the same tracks.
Yes.
And they also track, yes. And then I also want to point out tract F here in the right-hand corner where it says Grizzly Peak Water Sales and Distribution. Do you see that?
Yes.
That is the wastewater treatment plant location. Is that correct?
It is on tract F. Yes.
Thank you. You could put this down for now. Your Honor, it's 11:59. I am a potential stopping point, or I could go into my next section of the cross. I have a substantial amount of cross left in 3 areas. But this is a place where we could stop.
Question for you, do you say you have about an hour left for cross? Just I'm going from the cross-examination matrix, and that would be about,
It may be, I may have to request a slight extension of that time. It may be 2 hours, but
Hello?
but
okay,
that's about the amount of cross I have. We've had some interruptions and things that
sure. No, and I was accounting for that with like saying about an hour left. Okay, well, why don't I would prefer to take a break now if the parties are amenable to that. So I could continue on, but I don't want to go 2 more hours, so I got a break. So I suggest an hour lunch
This
break
is
now, or Mr. Larson
An hour lunch break now sounds great from staff's perspective.
and Mr. Davidson.
That'll work for the applicant, Your Honor.
Great. Okay. Looks like Mr. McAlpine has his hand raised.
I'm sorry, Your Honor. I just had a technical difficulty, I guess. I heard that we might take a break or there might be other testimony, but I did not hear the conclusion of the conversation.
All right. We are going to, everybody's on board with, we'll reconvene at 1 o'clock. We're going to take a lunch break and then we'll pick up where we left off.
Okay.
All right. So we'll go off the record now. Thank you, everyone. Before we go back on the record, Tracy, are you able to hear me?
Yes, I am.
Great, wonderful. All right, well, let's go back on the record and we are going to continue working, or excuse me, Mr. Detsky is going to continue with the cross-examination. I was reviewing the schedule over the break, Mr. Detsky, and it's not an exact science. I don't mean parties are held to the minute by what's in the cross-examination matrix, but to the extent you're able to truncate your questioning so it's not another 2 hours, that would be greatly appreciated. But with that, go ahead.
Oh, I understand, appreciate the leniency, and I will do my best to go as fast as I can. Mr. McAlpine, I want to now turn to discuss the loans that Cascade has undertaken that you provided in discovery. If you could please turn to your rebuttal 103 Rev 2 at page 18 at the bottom, Ms. Federico. Thank you. And you were asked here at the bottom what the company did to address the expenses described in that table. Can you scroll to the next page, please? And here you mention that Grizzly Peak Water and Sales received a loan and has incurred $309,000 in interest expenses as of 2025, which have accrued since 2021. Do you see that?
Sorry, I was on mute. Yes.
And you state that these were necessary and include recurring expenses for ongoing utility operations. Do you see that?
Yes.
And then at the bottom, the last sentence says, these expenses are supported by the memo drafted from the accounting firm of LB&J CPA on February 13th, 2026. Do you see that?
Yes.
So you testify that starting in December 2021, Cityscope began loaning money to Cascade. Is that correct?
Yes.
And you state here on line 5 that part of that was related to legal obligations associated with the system and related special district matters. Do you see that?
Yes.
Now, before we talked about legal obligations in the context of projects in process, are these the same or different legal obligations?
Well, you mentioned a fragment of that sentence. It says these expenses were necessary, including recurring expenses for ongoing utility operations, regulatory compliance, infrastructure maintenance, land use rights, administrative management, and legal obligations associated with the system and related special district matters.
I appreciate that. My question was, are these additional legal matters to the ones we discussed before in projects in process?
Likely, yes.
Likely?
Well, you're asking me to remember back to 2021, and I have an awful lot of management on my plate, so I'd have to go back and see what the line items were. But that sounds accurate that they would be.
How about special district matters? How are those related to this utility?
We've been investigating the special district since we took over management of it in 21.
And why is that a utility expense?
Creating a special district for the utility, or the utility becoming a special operating district, would be and I'm no expert on special districts, but a water and sewer district, which would, in Cascade or Grizzly Peak's case, allow for borrowing from state and various federal agencies, which right now it is not allowed.
Well, that's interesting because the WWE report, attachment 3, says that Cascade would be eligible from loans from the state revolving loan fund. And in fact, their report says that they factored that into their rate projections. Isn't that correct?
I don't know. I'm not familiar with that part of the WWE report, but I can say for sure from the management perspective, we have checked with the state fund and they said we are not currently eligible.
Okay. The expenses you say are supported by the LB&J memo, But we discussed earlier this morning that LB&J did not audit or verify any expenses you gave them, correct?
That's right.
Okay. Now let's talk about these loans you mentioned here in your rebuttal. You testified in discovery that Cascade does not have any regulated utility debt. Isn't that correct?
I don't remember that question and answer in discovery. Can you pull that up?
Yes. Ms. Federico, can you pull up hearing exhibit 300, attachment WB2, bottom of page 2, please? Do you see your question 1-11 at the bottom?
We submit that Cascade New Vision holds no existing debt. And then our answer was Cascade had no regulated utility debt.
That's correct. But in rebuttal, you have changed your story here, and you now claim that Cascade does have regulated utility debt and has since the moment you purchased the utility. Isn't that correct?
No, I think we have a terminology issue. We still believe it doesn't have any regulated debt. It doesn't have any debt from the state. It has loans from private entities.
What is the difference between loans from private entities and regulated utility debt?
The terminology.
Yes, please.
I'm not a lawyer. You can speak to that, but I believe that we have not changed our story at all.
Okay. Can you please pull up, Ms. Federico, hearing exhibit 318 from the associations box? And I'm looking at question 4-1 here at the bottom, going on to the next page. And this is the question that we asked you about the loan. Do you see this question in your response?
I do.
Okay. Can you please scroll down a little bit so Mr. McAlpine can see the rest of the response? Okay, thank you. Your Honor, I'd like to move for the admission of hearing exhibit 318.
Mr. Davidson?
As long as it's this question and answer, I have no objection.
Great. Admitted. Thank you.
Okay. I want to point you at A, where you say the loan funding reference consists of capital provided by ownership or entities under common management and control with the utility as well as third-party financing. Do you see that?
Yes.
And on the second part B, you say that the loans advanced over time to support utility operations, regulatory compliance, and infrastructure-related cost. Do you see that?
Yes.
Okay. And the next sentence says, to the extent applicable, interest associated with such funding reflects commercially reasonable risk-adjusted terms, generally consistent with a spread above prevailing market indices for similar risk profiles, typically in the range of prime plus a reasonable margin. Do you see that?
Yes.
Okay. So here you're saying that this loan represents funds advanced over time, sort of like a line of credit. Is that correct?
No, not like a line of credit, but it is loans advanced over time.
Okay. And you testify the funds were loaned under entities under common management and control, correct?
Yes.
And you testify these loans are at above market interest rates, correct?
No.
It says prevailing market indices with a spread above, correct?
They spread above prevailing market indices. That's not
Yes.
that's not a market rate, that's an indice. So a prime indicator, even if you borrowed for your home mortgage, it is something plus prime.
Okay.
So it's
So
market. That was your question.
So with this quest, in C and D, you said you attached promissory notes. And we're going to walk through those now. Ms. Federico, could you please pull up hearing exhibit 319 from the association's box?
I just want to clarify, because this is probably the second or third document we've pulled up that is not marked as confidential, but that when I open it, it has this watermark across the front. I'm just clarifying it's not confidential, correct?
It was not submitted as listed as confidential to
Okay,
us.
just making sure.
Yeah. But thank you for noticing that. I appreciate that. Mr. McAlpine, this is the promissory note that you provided, one of the promissory notes you provided in response to this discovery 4-1D, correct?
Yes,
Okay. And the amount is for 87,633.
yes,
And this December 31, 2021, that is just a couple of weeks after you purchased the utility, isn't that correct?
I don't know what the closing date was.
If I reminded you it was December 17, 2021, would that ring a bell?
And we didn't purchase the utility. Moorhead Property One purchased the utility. So
Actually, you testified earlier that City Sculpt, as member of Cascade, purchased the utility.
no, I did not. The contract was clear that Moorhead Property One was the buyer of the utility.
Well, we can let the record speak for
It's
itself.
been in the title chain the whole time.
Is your testimony now that Moorhead Property One owns?
Moorhead Property One owns the LLC Cascade New Venture.
And what is the Cascade New Venture?
That is, maybe I'm misstating the name wrong. I'm sorry, but that is the LLC that controls the utility that runs Grizzly Peak. Cascade New Vision, my mistake.
Cascade New Vision. Okay. And do you recall earlier that we looked at the purchase and sale agreement where there was a membership purchase agreement?
The
signed by
document, yes, I
City
do.
Sculpt? Okay. So City
Gentlemen,
Sculpt,
this is the court reporter. I'm just going to ask that you not speak over each other, please.
sorry. Let's move on. I want to go down and you see here and bullet point 1 that this is a fixed rate of interest at 8%. Do you see that?
Yes,
And then you see it has a running balance to it. Is that correct?
yes.
Okay. Can you scroll down, please, Ms. Federico? And I'm sorry, can we make this a little bit bigger? Thank you. And before we go up, can we go back up to the first top of it? Okay. I just want to show that the lender here is City Sculpt, Colorado, correct?
Yes.
Okay. Let's scroll down, please. And there should be a term. Was that three? Let's not scroll too fast. Was there? I think we passed it. Go up to number 3, please. Payment schedule. Thank you. This one says borrower shall pay in full outstanding balance plus accrued and unpaid interest 6 months from the date of execution of the note. Is that correct?
It does say that.
Okay. Has this loan been repaid?
No,
What was that?
I don't. No,
You don't know. Okay.
I don't think it has.
Okay.
No.
Okay. And the borrower here is not Cascade, it's Grizzly Peak Water and Sanitation. Isn't that correct?
Yes.
Okay. Thank you. Can we please, I would like to move for the admission of hearing exhibit 319, Your Honor.
Any objections?
No objection.
And
Admitted. Oh,
thank you. Go ahead. I'm sorry.
Oh, no, just admitted.
Thank you. Can you please scroll down to the bottom of this document, Federico? You signed this as borrower, isn't that correct?
Yes,
And you signed it as member of Grizzly Peak Water and Sales,
yes.
or sales and distribution. I misspoke earlier calling it water and sanitation, water sales and distribution. Thank you. You can please take this exhibit down and please pull up hearing exhibit 320. And can you make this a little bit bigger, please? This is the second promissory note you provided in discovery. Isn't that correct?
I assume we provided this, and I'll take your word that it was the second one.
Okay, thank you. It's dated December 31, 2022, a year later. Isn't that correct?
Yes,
And it's for the amount of $454,322. Is that
Yeah.
correct? Again, the borrower is Grizzly Peak Water and Sales Distribution. Isn't that correct?
yes,
And the lender is City Sculpt, Colorado, correct?
yes,
Same thing, paragraph 1, 8% interest.
yes.
And now let's look at this month loan balance table. If you could please scroll down, Ms. Federico. So this has the balance running again with loans each month. Is that correct?
Yes,
And then again, number 3, it says this note is also payable 6 months from the date of execution. Isn't that correct?
yes.
Has this loan been repaid?
No,
Okay. And so this loan amount now here at the bottom, 541,955, this means it's additive. In other words, 454 plus the 87 from the first loan. Is that correct?
yes,
Thank you. Can you scroll to the bottom of this, Federico? Here again, you sign this as member of Grizzly Peak Water and Sales. Isn't that correct?
yes.
Okay. You could please take this one down. Oh, sorry. We move for the admission of hearing exhibit 320, Your Honor.
Any objections?
No objection.
Admitted.
Thank you. Can you please pull up hearing exhibit 321? Thank you. Mr. McAlpine, this promissory note is 1 year later, December 31, 2023, correct?
Yes,
This is for $351,540. Is that correct?
yes,
Same borrower, Grizzly Peak Water and Sales Distribution, correct?
yes,
Same lender, City Sculpt.
yes,
Same interest rate, 8%.
yes,
And if we could scroll down, Ms. Federico, to the table here. I see this running balance taking you up to a running total of 893,495 in debt, which means it is additive on top of the 542 and the 87, correct?
I'd have to check our books, but it looks to me like at this point we started updating past loans and collapsing it into the next year.
Okay. And if you could please look at number 3, this is also said it is due 6 months from the date of execution, correct?
Yes,
Okay. Has this loan been repaid?
no,
Okay. Can we please scroll to the bottom of this? You again signed this loan as borrower for Grizzly Peak Water and Sales, isn't that correct?
yes.
Okay. Your Honor, I'd like to move for the admission of hearing exhibit 321.
Any objections?
No objection.
Admitted.
Ms. Federico, can you please put up hearing exhibit 322, please? This promissory note is 1 year later, December 31, 2024. Isn't that correct?
Yes.
It's for the amount of $334,720. Is that correct?
Yes.
Same borrower, Grizzly Peak Water and Sales Distribution, correct?
Yes.
Same lender, City Sculpt, correct?
Yes.
Same interest rate of 8%. Is that correct? And now looking at that table, now we're at a running balance of 1,228,215. Is that correct?
Yes.
Okay. So if we can scroll down to paragraph number 3. This note also was payable 6 months from date of execution, correct?
Yes.
This has not been repaid, has it?
What? No.
Okay. Can you please scroll down to the bottom, Ms. Federico? You again signed this as member of Grizzly Peak Water and Sales Distribution, isn't that correct?
Yes.
Thank you. Your Honor, I'd like to move for the admission of hearing exhibit 322.
Any objections?
No objection.
Admitted.
Ms. Federico, can you please pull up hearing exhibit 323? This promissory note is from August 27, 2025. Do you see that?
Yes.
It's for $150,000, correct?
Yes.
And the borrower again is Grizzly Peak Water and Sales Distribution. Is that correct?
Yes.
And now this one is the lender is the Conaway Trust, Joshua K. Conaway, and Janae M. Conaway. Do you see that?
Yes.
Correct. And this interest rate is now at equal to, it says 8% and it says 12% on this note. Which one?
It's a typo. It's 12%.
12% interest. Okay. So that's about 4% interest in the other debt that Grizzly Peak has taken on, correct?
Yes.
Okay. Can you please scroll down on this one? And all the way down to the bottom, please. Here we go. Oh, no, I'm sorry, right there. Thank you. Is that your signature on behalf of Grizzly Peak Water and Sales Distribution?
Yes.
Thank you. Your Honor, I'd like to move for the admission of hearing exhibit 323.
Any objections?
No objection.
Admitted.
Can you please pull up hearing exhibit 324, please? And can you make this a little bit bigger? Thank you. This is a promissory note with the borrower being Grizzly Peak Water and Sales Distribution. Do you see this?
Yes.
And I see it's in the amount of $500,000. Is that correct?
Yes.
And this loan is dated December 1st, 2025. Isn't that correct?
Yes.
That was during the middle of this case that we're in. Isn't that correct?
I don't know the timing of the case, but that sounds right.
Okay. And if I look into the paragraph, it's a lot of small type, but I see an initial 1, 2, 3, 4, 5 lines down under payment. It has an initial interest rate of 7.5%. Is that correct?
Yes.
Then it has a margin, the next 2 lines down, of 0.5% and 1 principal interest payment on December 30th with interest calculated on the unpaid balances using interest rate based on the index described below plus a margin of 5%. Do you see this?
It's 0.5%, but yes.
0.5%, sorry. And this is from Alpine Bank, correct, as the lender?
Correct.
Okay. Can you please scroll down to page 3 of this document, Ms. Federico? Here it says collateral. And under collateral, you said that borrower says this note is secured by the following collateral and security instruments listed below. And these are two deeds of trust. Do you see that?
Yes.
Okay. Can you please pull up? Well, we'll turn to that in a second. Let's finish with this one, and then we'll go to the next exhibit. You told the association in discovery that Cascade does not own any real property. Isn't that correct?
The Cascade, what? There's,
Cascade, the utility, Cascade New Vision.
no, I don't believe I said that in Discovery. Cascade New Vision owns the utility operation.
And
So
the
it's not
utility,
property.
sorry to talk over you, sorry. Go ahead.
It does not own real property, but there are other Cascade entity LLCs that own real property.
Correct. But Grizzly Peak and its member, Cascade New Vision, you testified do not own any real property, correct?
Correct.
So who owns these properties that were used as collateral as a loan to Grizzly Peak Water and Sales?
Cascade Meadows LLC owns the first one, I believe, and Cascade Hospitality LLC owns the second one, I believe.
So Alpine Bank accepted as collateral deeds of trust for properties that the utility does not own, correct?
Correct.
And that's because affiliates of the utility own and pledge this collateral. Isn't that correct?
No,
You're saying that Cascade Meadows submitted this collateral without its knowledge?
not without its knowledge. I'm not agreeing that they're affiliates.
Okay. What about Cascade Hospitality? Were they aware that this collateral is being submitted for the utility?
Yes,
Okay. And is your testimony that this is not an affiliate?
correct.
Okay.
I don't know the legal definition of affiliate, so that could be inaccurate.
Okay. Well, let's just say under common management and control. Does that make it
They are
easier?
under common management. Yeah, so I guess it would be an affiliate.
Okay, thank you. Can you please scroll down to the signature on this? Right here, stop right there. Thank you. This is unsigned, but it has a signature block for Mr. Thomas Jordan on behalf of Grizzly Peak Water and Sales. Do you see that?
Yes,
And Thomas Jordan was one of the people you testified this morning, along with Michael Miller, are employees of yours who are under common management of the various affiliates, correct?
no, that's incorrect.
Okay. Are you changing your testimony?
No, that's not what I testified.
Okay. We can let the record speak for what you testified this morning. Your Honor, I'd like to move for the admission of this exhibit 324.
Any objection?
No objection.
Admitted.
Thank you. We could take this down, Ms. Federico, and I would like to return to hearing exhibit 300, attachment WB2 at page 14. Thank you. And can you scroll up a little bit? I want to capture 2-10. Thank you. In this question, you were asked about the amounts that were shown as payable to City Sculpt on attachment 4 of the application. Do you recall that?
I recall this question, yes.
Okay. And in sub B, you provided a table that is a summary of investments. And can we scroll down to that table? And this was a summary of the investments due to City Sculpt. And do you see that the total there at the bottom right being $2 million, $2,052,000?
I do.
Thank you. Ms. Federico, I want to jump back to hearing exhibit 305, the demonstrative exhibit at table 4, the last page. Thank you. And this is the last page of the demonstrative exhibit, Your Honor, and I have taken that hearing exhibit, that 210 response, and we've put the loan amounts underneath to show how they match up with those costs. And I want to look at the column 2025 on the right side, Mr. McAlpine. Because when we added that number of the total due to the outstanding loans, there's another $600,000, $639,000 in 2025 of debt that it was incurred by Cascade, correct?
Yeah, it appears so. I've never seen this chart before.
Well, this is the chart that you provided us that we just walked through in 210. And then beneath it, I've put the promissory notes along with their running total. So do you agree that adding the 2025 debt to this chart, that currently Cascade Village is indebted to Citysculpt, or Cascade Utility is indebted to Citysculpt at $1.743 million. Is that
Your Honor,
correct?
I'd have to, I think, object at this time. This says ICO City Sculpt. The earlier versions dealt with City Sculpt Colorado. And I'm not sure that those are the same entities, so I'm not clear where we're going with this. So I'm not sure it's identifiable, first of all, but relevant as well, because I'm not sure these are the same entities.
Mr. Detsky.
Again, Your Honor, this is the response that Mr. McAlpine gave to us. So we are repeating his numbers. Now, there was I admit the letters ICO are in there, and we can point, I think, with some time, we could point to where Mr. McAlpine answered in discovery that ICO is just a naming convention that they used in their reports, but these are the same Citysculpt loans that we just went through, and this is put up next to the charge of Citysculpt expenses that Mr. McAlpine provided in discovery. So there's nothing new here in this document.
All right, thank you. I'll allow it.
So do I see here, I see a total owed now at the end of 2025 from Cascade to Citysculpt of $1.743 million. Is that correct?
Well, that's what the number in the block says. I'd have to check with accounting to check the accuracy of that.
Okay. And is there a 2025 promissory note that was entered into between Cascade or Grizzly Peak Water and Sales and Citysculpt?
Yes, there would be.
And you have not provided that yet in discovery, correct?
If we'd been asked, I would have thought we provided it, but I don't know the answer to that.
Okay. Would you be willing to provide that to the record in this case if there is a promissory note in 2025?
Yes.
Thank you. These $1.74 million in debt, this is in addition to the $150,000 debt to Conaway Trust, correct?
Correct.
And in addition to the $500,000 loan facility from Alpine Bank, correct?
That's why all three of those loans need to make sure that they're reconciled. So
Well, they're additive, are they not?
I don't know that. They may not be. One lower interest rate loan from Alpine, for instance, may have relieved some debt from the other two lenders.
Well, there's no evidence that any of this debt was repaid, correct?
But again, I need to check with bookkeeping to see how they've allocated that.
Well, if we add the Alpine Bank and Conaway Trust loans to this 1.74 million in debt for these expenses that you've put here, I get about $2.393 million in total debt on Grizzly Peak Water and Sales as of the date of this hearing. Is that correct?
That sounds right.
And that for 160 customers this utility serves, that averages to roughly $15,000 in debt per customer. Is that correct?
I'll take your math for granted.
And you say in your testimony that this debt has incurred here an interest due investor line, this row, that the utility has paid $309,000 of this loan money as interest on the loans. Is that correct?
That's the total that shows up in that box.
Okay, thank you. You could take this one down, Ms. Federico, and please open up again CLM 10 at page 5. At the bottom of this sheet, please. Right there. So here again is ICO City Sculpt at the bottom of this under liabilities. Do you see that?
Yes.
Okay. These loan amounts here at the bottom, 435,000, 600,000, 508,000. These loans total about $1.5 million from 2022 to 2024. Is that correct?
I'll take your word on that. It seems about right.
Okay. These loan entries do not match the loan amounts that we just walked through in the promissory notes. Isn't that correct?
The numbers are different, but this could be on an accrual basis and the other be a cash basis, or they could not match. This is I believe the top of this document was 2024, so they may not have been reconciled.
No, this document is from February 13th, 2026.
Can you go to the top of this page?
Page 1, please.
No, go to the top of the exhibit document.
This is the top of the exhibit document? Did you mean the top of the,
This is their letter. The exhibit's attached, isn't it?
it's all one exhibit.
So
Did you mean,
stop here, stop. That's the date I saw. December 31, 24.
Right. So if you can go back down, the amounts here listed as ICO City Sculpt on page 5 at the bottom, Ms. Federico. Okay. Liabilities, ICO City Sculpt, this number, 435,000 from 2022, this does not match the loan that you
It
took
depends
to
on
borrow from yourself in 2022, correct?
I did not borrow it from myself.
Well, you control 90% of the borrower,
The lender.
and you were also signed as well, you control 90% of the lender, correct?
Yes,
City
you misstated that. I am not the borrower. I'm the
And
manager.
you signed as the borrower.
I signed as the manager for the borrower.
You signed as the member of Grizzly Peak Water and Sales Distribution,
That
correct?
could have been titled wrong. I am the manager of that. And I am a member.
And that promissory note from 2022 and the one from 2023 and the one from 2024, none of those match what you've put here in the LBJ report, correct?
The numbers are different, but again, I'd say this is not necessarily reconciled. I'm not sure anybody asked LBJ to reconcile it to the same date.
Well, I think, didn't you testify that you asked LBJ to reconcile all the financial data and that this is your support for this application, correct?
We asked LBJ to reconcile all the financial data. We did not give them a as of date. And so I'm saying it appears to me that these dates are incorrect.
Okay, so the LBJ report is wrong, you're testifying, correct?
Nope. Saying the numbers don't match. I don't know which one's wrong.
Okay. And the LBJ report clearly was not in possession of the promissory notes, correct?
I don't know if they were or weren't. I'd have to ask the bookkeeper if she provided those.
Okay. And if we can go up to page 4 of this document, please. Under expenses, I will show interest expense. Do you see that line?
Yes.
And it says 2022, 2023, 24 with a total of 182,000 $914 of interest expense. Do you see that?
Yes,
Okay. And you agree that this interest expense does not match the interest expense that you provided in this Discovery 210 that totals $309,000, correct?
they are not the same number. I believe that you're comparing apples and oranges.
So LB&J got wrong the amount owed to Cityscope and the interest that has been paid. Isn't that correct?
I didn't say that.
So tell me, is this correct or is this incorrect?
I didn't say either. I said the numbers don't reconcile, which is the fact that we see here. It doesn't mean that they're correct or incorrect. It could be a data problem. It could be a date problem that they weren't reconciled to a certain date.
Mr. McAlpine, this is the document that you are relying on to support your case for the operating expenses of the utility and the revenue deficiency. And you're saying these numbers are incorrect or do not match. Is that right?
I'm saying of the two documents you showed us, the numbers do not match. I'll agree with that for sure.
Okay. And the two documents I showed you are the report provided by your accountants and the expenses you provided in Discovery, correct?
Yes.
Okay, thank you. Mr. McAlpine, in your rebuttal, you do not describe any single capital project that the proceeds of this loan were spent on. Isn't that correct?
Are you referring, is there a question to a specific rebuttal?
No, I'm saying in your rebuttal, I did not see anywhere any capital investment that you have made with the proceeds of this loan in the utility. Is that correct?
I'll let those documents speak for themselves.
Can you now here identify any project for the Grizzly Peak utility that was funded with the proceeds of these loans?
Yes, it's significant work through both the attorneys, Mark Davidson here, attorneys for water rights, attorneys helping with other rights that may exist on site, the possibility of expanding the system, which brings in consultants, Marsa's time. There's a variety of them. There's a lot.
I'm asking for an infrastructure project.
I just started giving you those.
No, not lawyers. I'm talking about an actual project that you've invested in the utility, not personnel.
Do you want to then define that by hard cost and soft cost? Because it's impossible to begin spending the hard cost until we've invested the soft cost to get plans and engineering done, which is what we've been doing with Wrightwater and
I'm asking,
others.
you have here, we've looked at $2 million in debt that you have undertaken and signed off on this utility for. And I'm asking you for anything that's on the ground that we can look at as an investment that you've made in this utility.
Again, I'm asking you if you're trying to define that by hard cost or soft cost, because the investment in the utility has substantial soft cost up to this point.
I understand that. I'm asking what projects?
So you're asking about hard cost.
Yes, hard costs.
So what we've done is repaired lines, and we've done ground testing and well preparation. And that's about it.
And what do you mean by well preparation? These wells have already been dug and are servicing the utility before you purchased it, correct?
No, there's two. It may be a better question for Dave Marson, but I believe there's two wells in operation with permits. Excuse me, there's multiple wells in operation with two others that are permitted and ready to drill, and we have done some investigative hard costs to work towards drilling those in the future. We've
And
also, yep.
this various loans, these show zero in loan repayments to date, correct?
I don't think that's accurate. Again, I'd have to look at the bookkeeping, but I do believe that some debt was repaid when the Alpine loan came in because it was slightly cheaper debt.
So I'm asking the evidence you provided in this docket, do you show any repayment of these loans?
Well, I think that's why the balances may not match. So there may not be a specific repayment line, but balances of the loans have been up and down, and as you pointed out, they don't exactly foot or match.
So
And
you're saying any repayments did not make it into the profit and loss statement put together by LB&J?
They were not asked to focus on repayments that were made. And they were given outstanding notes. They wouldn't have been given notes that have been, or partial pay downs that would have happened.
Is there any amortization schedule on these loans?
We could provide one. I don't know if we have a summary of them. Simple interest, so the amortization is pretty straightforward.
And we only have these loans in the record now because you provided them to us in discovery, correct?
Correct.
So you never presented these loans to the commission for approval, correct?
For approval, if we were meant to do that, we'd apologize, but I don't think that we did for approval.
And
We're certainly made.
for all but the 2025 loans, these amounts have all come due, isn't that correct?
They're due if the lender demands.
And the lender is you, correct?
The lender is an entity, which I am a member of.
Okay. We could take this one down, Ms. Federico. The next topic that we need to discuss is the land lease. If you could please open hearing exhibit 300 WB4, please. Attachment WB4. Oh, I apologize. It could be, I'm sorry, WB5. I apologize. Thank you. This land lease, it's between Moorhead Property 1 as the landlord and Grizzly Peak Water Sales and Distribution as the tenant. Is that correct?
Correct.
And it's dated December 21, 2021. Is that correct?
That's the date on the face, yes.
And so this would be about 1 week after you closed on the transaction, correct?
After Moorhead Property 1 closed, yes.
Yes. And this says is for 3 acres, correct?
That's what it says, yes.
Okay. And we could scroll to page 4 really quick of this, Ms. Federico. Stop right there. Thank you. Oh, at the top. Yeah. We looked at this map earlier, but I wanted to point out this is 3 acres tract F that we discussed earlier this morning is the location of the wastewater treatment plant, correct?
The site of the wastewater treatment plant is tract F, and it is approximately 3 acres.
Okay, thank you. And so can we go back to page 1? And let's look at number 3, rent. This says the annual base rent is $180,000 per year. Do you see that?
Yes,
Escalating each anniversary at the rate of 2% or the CPI for all urban consumers. Do you see that?
yes.
Okay. And if we go back into your accounting, which we can in a few minutes, you have shown now $180,000 has been paid by Cascade by Grizzly Peak to Moorhead Property 1 in each year since this lease has been in effect, correct?
No, that's not correct.
It has not been paid?
Not been paid.
It has not been paid. Okay, can we go to CLM 10, please? And can we go to page 4, please? Do you see the line item rent on this page?
I do.
It says $180,000 paid each year in 2022, 23, and 24. Is that correct?
I don't think that's what it shows. I believe this is on an accrual basis.
This shows,
It shows a debt of 180,000.
this is a profit and loss statement, not a balance sheet.
It's possible that it got misstated in accounting, but that has not been paid. The utility's not had the resources to pay it.
Can we please look at the demonstrative exhibit again? Table 4, this is hearing exhibit 305.
Table 4, you said that's on the last page, right?
Table 4, yes, last page. One more page. Thank you. This is the response 210 you gave showing expenses owed to CitySculpt. Do you see land lease, $180,000 each year in 2022, 23, 24, 25?
I do.
Okay, this is the numbers that you provided us, correct?
Yes.
Okay. And that is the amount of this lease, correct?
Yes.
Okay. Let's go back to that, the WB5, please, where we were. So when you were doing, if I'm adding 180,000 a year, that means that by the time you get to the end of 2026, 22, 23, 24, 25, 26, that Cascade will have paid $900,000 on this lease to Moorhead Property One. Is that correct?
I'll take your numbers for granted. Cascade's never owned the land underneath it, even before any of these entities bought it. So
No.
it does pay a typical market land lease for that.
I'm just asking about the amount, $180,000 a year, 5 years, paid to Moorhead Property One, $900,000, correct?
That sounds accurate. Unfortunately, I can't do that in my head, even though it's
Okay. Can we please go down to paragraph 6 of this? Taxes and assessments. It says tenants shall pay all real property taxes, general and special assessments, and government charges levied against the premises. Do you see that?
yes.
Okay. Now, in discovery, you admitted that Cascade paid $53,000 in real estate taxes in 2023 and 2024 under this provision of the lease. Is that correct?
Cascade did or Grizzly Peak did?
They are one and the same entity, according to your testimony.
No, that's not what I testified. Grizzly Peak or Cascade New Vision is the utility operations entities. And
Okay.
they would have paid the taxes per this lease. Taxes are the first thing gets paid out of any general funds.
Okay. And that amount they've paid in 2023 and 2024 was $53,829. Is that correct?
I'll take your word on that. I
Okay.
don't remember the tax bills.
Okay. So let's scroll down to paragraph 10 of this, please. Improvements. Here it says all improvements constructed by a tenant shall remain the property of tenant during the lease term and any renewal term. Upon expiration or earlier termination, such improvements shall revert to landlord unless otherwise agreed in writing. Do you see that?
Yes.
So this says that the wastewater treatment plant at the end of this lease will become the property of Moorhead Property One. Is that correct?
It's a typical land lease provision.
But here we have a regulated utility that is promised to give its assets to a landowner, correct?
It's not giving, that's the terms of the lease for using the land that they don't own.
I see. And let's turn to the page 3, please, of this lease. Okay. Here I see the lease is signed by Moorhead Property 1 by someone named Thomas Jordan. Do you see that?
Yes.
And that Thomas Jordan is the same Thomas J. Jordan who was to sign the Alpine Bank loan on behalf of Grizzly Peak Water and Sales, correct?
He would not have signed on behalf of Grizzly Peak. He may have signed on behalf of Moorhead Property 1.
Do we want to, we'll go back and we will ask.
The document you showed earlier was unsigned by either him or Miller.
It's true, this is a document that you provided us that was unsigned, but was not Thomas J. Jordan listed as the signatory for Grizzly Peak Water and Sales?
He was listed, but I don't know that that was a draft document. He would not have been the signature for Grizzly Peak Water Sales.
Mr. McAlpine, you were the one who provided that document to us. So you would be the one to know if that was the correct document. And if you had provided us a wrong document, you could have corrected it. But the document you provided said Thomas J. Jordan signing the loan on behalf of Grizzly Peak Water and Sales Distribution. Isn't that correct?
Objection, that characterizes his testimony.
Your Honor,
Mr.
I'm simply
That's-
asking him to confirm what we looked at before.
Understood. Can you rephrase the question without using any testimony? That makes sense.
Yes. Can we please, Ms. Federico, return to hearing exhibit 325, please?
Uh, 325 is a new exhibit. I just want to make sure that that's what you meant.
No, 325 was admitted already as the Alpine Bank loan.
No, 325 is still in your box. That's deed of
Oh.
trust, Cascade Meadows.
Oh, I'm sorry, 324, my fault. Can you scroll to page 3, please? Mr. McAlpine, do you see at the bottom of this document that this loan was to be signed by Thomas J. Jordan on behalf of Grizzly Peak Water Sales and Distribution, LLC?
I see that they've labeled it that way. What I was pointing out is it is unsigned, and it would be common for a bank to make an error like this, that it was probably corrected at the actual loan closing.
Do you have a copy of the
I don't
signed
think we
loan?
do. If we did, we would have provided it. And I
So,
believe Todd Wolfram would be the right signature. So I think the bank was just putting
I'm
names.
sorry, Mr. McAlpine, can you say that name again, please?
I'm sorry, that it actually says by Thomas J. Jordan, by Todd D. Wolfram, attorney in fact. Todd Wolfram would have authority to sign on behalf of Grizzly Peak.
thank you. So you don't have a signed copy of this lease, is that correct? I mean,
Not that I know.
I thought you do not. Do you have a recorded copy of this loan?
I'm sure that the bank does. I don't know that we got final documents.
Would you be willing to provide the recorded final copy of this loan?
Absolutely.
Thank you. Can we go back to WB5, Ms. Federico? Thank you. The tenant on this, so Thomas Jordan signed this on behalf of Moorhead Property 1. The tenant, Grizzly Peak Water and Sales Distribution, LLC, signed by Michael Miller. Do you see that?
Yes.
Now, this morning, you testified that Michael Miller signed a week earlier from this document the closing on this property as the manager of Moorhead Property 1. Isn't that correct?
I'll refer to that testimony.
Mr. Miller also signed the agreement to purchase the utility on behalf of Citysculpt. Isn't that correct?
That sounds accurate.
You testified that in your rebuttal that one reason for Cascade's failure to submit annual reports to the commission in 2023 and 2024 was a change in the CFO. Isn't that correct?
That's correct.
But the CFO of Grizzly Peak here was Michael Miller in 2021, and Michael Miller is the CFO of Citysculpt today. Isn't that correct?
That's incorrect.
Ms. Federico, can you please pull up hearing exhibit 317? Mr. McAlpine, I'll represent to you that this is a web page for the website LinkedIn that we pulled up today. And do you see that this web page is a profile for Michael Miller, CFO at Citysculpt?
I do see that.
Do you think that Michael Miller is not the CFO at Citysculpt?
Michael Miller is not the CFO at Citysculpt.
Okay,
And Citysculpt did not create this webpage.
right. Michael Miller did, correct?
I assume so.
Okay. Have you seen this web page before?
No.
Oh, we could take this exhibit down. It's Federico. I want to turn back to your rebuttal here. Can we please turn to hearing exhibit 103 at page 12? At line 15, can we scroll down to that? You state that the rental rate for the wastewater treatment facility location is a market-based rate for the use of land and its stated purpose. Do you see that?
Yes.
You did not provide your own basis for what is a market-based rate. Is that correct?
We provided what we had.
What you pay.
Well,
As a land developer, have you heard of the term cap rate?
I have.
Do you agree that a cap rate is a standard method for calculating the market rental value of a property?
It is one method of calculating a rental rate.
And so do you agree that, let's say, a 6% cap rate might be a standard value for a cap rate?
There's no such thing as a standard value for a cap rate.
There's no such.
Cap rates fluctuate widely depending on the risk of the asset.
Okay. So let's just use 6% for this. If I wanted to figure out the cap rate, or if I wanted to use the cap rate of 6% on a $180,000 a year lease, then I would divide 180,000 by 6%. Is that correct?
No one would ever use 6% on this sort of an asset. But if you're asking what the formula is for a cap rate calculation, you're correct.
Okay. So what rate would you use for this asset if 6% would not be used?
But we didn't do a cap rate analysis here. I would probably consult with some brokers and appraisers before we would determine what cap rate to use, but it would be a double-digit cap rate.
A double-digit cap rate. Because if I just used a 6% cap rate on a $180,000 lease, then I would get a property value of about $3 million. Does that sound right to you?
Yep.
Okay. And you testified that you paid 1.5 million here for 44 acres of property, correct?
These entities, Moorhead Property One, bought that with all the associated risk and knowing it was going to need to borrow significant amounts of money to right the situation that had been a distressed asset. So that was their closing number.
Okay. So what was the basis for your $180,000 rental rate then?
We looked at the alternative use, which is also an appraisal method. And I don't have the calculation in front of me, but we said but for, if you will, here, if the utility plant did not exist on this parcel, what else could it be used for? That was what I would call a but for, or an appraiser would call it an alternative use.
But you
It would
purchased,
not be a cap rate. Your statement of a 6% cap rate is a 6% cap rate on a land lease is what you would get if you had a guaranteed lease from Bank of America for a branch. It would be significantly less risky than a private utility on the top of a mountain.
and
So
you
that cap
purchased,
rate would double.
you purchased this property and the utility with this wastewater treatment plant, correct?
I did not purchase it, Morehead Property One purchased it.
Correct. Sorry. I want to look back at the annual reports that you filed for Cascade to look at what the market rate was for this property. If we could pull up what's been admitted as hearing exhibit 310, please. Thank you. And we discussed earlier about how you filed this report on behalf of Cascade. If we could scroll down to the date. Thank you, right there. So in this, oh, I'm sorry, this is not the date, but let's come back to that date. I'm sorry, I apologize. I want to turn to page 4. And I want to look at line 35. Thank you. Do you see that line rents, Mr. McAlpine?
Yes.
Do you see that rents is showing as 16,480 in 2021 and 20,000? Sorry, I can't read that last number in 2022.
I see those numbers.
Okay. Can we go to page 6, Ms. Federico? And thank you. And I want to look here at the rents. Rental of building real property on line 38. Do you see that?
I'm gonna have to expand it. Give me 1 second. Yes.
That shows a rent of $6,963 for the sewer of building and real property in 2022. Isn't that correct?
Oh, yes.
So even though the Morehead 1 lease was in effect in 2022, the $180,000 rent payment was not reported to the commission in 2022 for water or sewer. Isn't that correct?
This document speaks for itself. I don't think that the two necessarily connect to each other. One may be on cash, which would explain the odd number in that box, and one may be on accrual. So the amount they were actually able to pay may have been $6,900, but their debt's still $180,000.
So this shows 2021, $16,480 in rent. Do you see that?
Yeah. Why would the number fluctuate so drastically from year to year?
It's a good question. I didn't own the utility though. But that number, 16,480, it is a viable number of what was paid for rent on that property in 2021, isn't it?
It's the number that's in that box. I don't know if it's viable or not. Again, I have a feeling that this is on a cash basis where the other's on an accrual. There's something wrong with this.
This is the 2022 annual report for this utility that you filed, correct?
I assume so, yeah.
Okay. I'd like to open the 2023 annual report that you just filed with your rebuttal. And I believe that is now going to be, I'm going to get this wrong, attachment CLM 7. Yes. Okay, great. I want to go down to line 35 of this on page 6. Do you see this? Line 35?
Looking, yeah, I do.
Okay, this is what you just filed for 2023, and it shows $180,000 in rent for 2022. Do you see that?
Can we go to the top of this? I don't want to see what the column is on the label on the columns are.
Oh yeah, one page up, sure.
Yep, I see that. So it looks
Okay.
like it was reconciled from 22 and 23.
So 2022, you filed in, when you filed your 2022 report, you said it was $6,000 in rent, or $16,000 for 2021. And now we're at 180,000. Is that correct?
That's the filings.
Okay. And between the two reports that you filed, one in 22 and then this one, the lease price jumped by about 1,000%. Is that correct?
I didn't calculate that. It jumped. You're making an assumption it jumped from 21 to 22, but it's actually from 2009 to 2023.
I'm not sure what you mean by 2009.
Well, the lease payment hadn't been adjusted since the inception of the utility.
Well, can we please pull up, Ms. Federico, hearing exhibit 327 from the association's box? Thank you. Your Honor, I will represent to you that this is the 2021 Grizzly Peak Water and Sales Utility Financials and Annual Report that was filed by Mr. McAlpine. I would like to move for administrative notice of this 2021 annual report.
Any objections?
No objection.
Admitted.
Thank you. Mr. McAlpine, you filed this annual report in 2022 on behalf of Grizzly Peak Water Sales and Distribution. Isn't that correct?
I'll take your word for it.
Okay. I want to look at this financials document here. Can you scroll to page 4 of this document, Federico? Right there. Thank you. Under this income statement, I want to go down to what you have here as towards the bottom. You have land lease tract F. Do you see that line?
Yes.
Do you see that line was as allocated to sewer, $14,500, correct?
I'm trying to follow where it says as allocated to sewer.
If you go to the top of that column, it says as allocated.
Ah, I see.
Do you see that number?
Yes.
Okay. Can we scroll down to page 14 of this document? Okay. So here you have in this document rents for water, and I see 2020, 17,553, 2021, 16,480. Do you see those numbers?
What line is that? I'm sorry.
That's line 35.
I see those numbers.
Okay. And I want to go to the next page, please. And one more. Thank you, Ms. Federico. Here we have that same line 38, rental of buildings, real property for sewer. And I see 13,750, 2020, 16,480, 2021. Do you see that?
I see those.
Okay, so here, this is contradicting your statement that rents had not changed since 2009, right? Here we have rents in 2020 and 2021 changing. Isn't that correct?
Again, I think this is a cash basis. If the sheet you just referred to had the rent going down and this has it going up, it's kind of all over the board. So what we did, again, in 2021, we were given the task to rebuild the financials with zero data from historical data to put Grizzly Peak to be able to make an annual report when we may have to revise them. But these numbers, as all the numbers you've shown me related to rent and rent of buildings, have gone up some years, down some years. And what we did with an established land lease is we normalized that. It
And
looks
you normalized it from 16,000 to 180,000. Is that correct?
depending on how they measured it, but you've got two categories there, so it's at least double the 16,000. But I don't know how they did the books before we arrived.
Well, this year ending 12/31/2020, you did not own the utility at that time, did you, Mr. McAlpine?
Right.
So you got these numbers from the prior utility, correct?
We got them from prior filings. We got an incomplete set of books that hadn't been audited.
So prior filings would mean annual reports submitted to the commission, is that correct?
I think so, yeah.
Okay. So in discovery, you admitted that Cascade owns its sources of water now, its raw water supplies, isn't that correct?
Cascade.
Yes.
Cascade New Vision would own the water supply, yes.
Okay. So there should be no further rental payments for water, correct?
That sounds right.
Okay. We could take this exhibit down, Ms. Federico. And can we go back to hearing exhibit 103, which is the rebuttal testimony at page 12? Thank you. Line 20, please. Here you state, furthermore, the rental rate for the land is pursuant to a written lease agreement with the stated rental rate subject to review and audit by the commission at any time, which has never occurred. Do you see that?
Yes.
Well, based on the 2022 annual report we just looked at in 2021, the commission could not have known about the Moorhead 1 lease or whether it was in effect because it was not shown as an expense of Cascade, correct?
But I think the subsequent document you showed, it was altered in 2022 to show the lease.
Do you mean the 2023 annual report that you filed with your rebuttal case?
You said it was a report that we filed and you drew me to the line that showed 180,000.
Yes, that was the 2023 annual report that you filed with your rebuttal case in this proceeding, correct?
Yes.
Okay. So it's only at this time, at this hearing, that the commission has ever been made aware of the Moorhead 1 lease to Grizzly Peak or the existence of the $180,000 lease payment. Isn't that correct?
But that I don't know. You pulled up a document that you said we'd filed that showed the 180, but
Yeah.
it's a typical land lease for the cost of doing business on someone else's land.
You filed this document last month, correct?
Okay,
And we do have data from 2021, 2020 in your prior annual reports that shows what the utility was willing to pay for this piece of ground, correct? To rent it.
no, that's incorrect.
And we do have a document that shows that CitySculpt has loaned $1.7 million to Grizzly Peak, who has then paid $900,000 back, or $720,000 at this point, back to CitySculpt, or sorry, to Moorhead for rent on this property, correct?
No, that's incorrect.
One final area of questioning, Your Honor. I want to turn back to hearing exhibit 312. And this is previously admitted. This is the San Juan County Commissioner's packet that we talked about before. And if you could start at page 15, please. And we talked about, and we showed the map here for the 72 units on tract A1 and B1. Do you recall that conversation we had earlier?
Yes,
Okay. And you testified that these are properties that Cascade Meadows owns, but that which were purchased by Moorhead Property One, correct?
Moorhead Property One owns the LLCs Cascade Meadows and Cascade Hospitality.
Moorhead, okay. So when this says tract A1 is owned by Cascade Meadows LLC, what it should say is it's owned by Moorhead Property One.
No, that's not what you asked. Cascade Meadows LLC does own tract A1.
It does. Okay.
Yeah.
And Moorhead Property One sold the property to Cascade Meadows, or it just owns Cascade Meadows, you say?
Moorhead Property One owns the majority stake of Cascade Meadows,
Okay, thank you.
or they did.
Can we go to page 41, please? Okay. This part of the application mentions Metro District and Utility Company. Do you see that?
Yes,
And it says Cascade New Ventures, LLC. And you had said earlier this morning, you talked about Cascade New Ventures, and you said it doesn't exist, but here it is, Cascade New Ventures, LLC.
it's not actually what I said, and it wasn't this morning.
Okay. Well, this says Cascade New Ventures, and I think you mean Vision, owns the operating company Grizzly Peak Water Services LLC, which I think you mean Water Sales and Distribution LLC. Is that correct?
Again, I don't think I drafted this document, so I think that is what was meant in this document.
Okay, thank you. I want to go down to about the fourth paragraph that starts with respect. Do you see that?
Yeah,
This says, with respect to the planned Cascade Meadows development, Cascade New Ventures / Grizzly Peak will design, fund, and construct all utility infrastructure, including roads, water and sewer lines, and associated improvements at its own cost. Do you see that?
yes.
Now, are you aware that this development application says that this utility will build roads at its own cost?
This development application, yes.
Is it your testimony that Grizzly Peak can build and maintain roads?
That they have the authority to do so?
Is that your testimony?
Is that your question?
Yes.
Yes, I think Grizzly Peak has the authority to build and maintain roads.
Okay. Can you please go down to page 43, Ms. Federico? I want to scroll down to point 8 on this. It says, there is not an HOA as part of this development at this time. The developer is working on a special district. Currently, the public utility will maintain all parts of the development until the special district is formed. Do you see that?
Yes,
So, am I correct, Mr. McAlpine, that in this application, Cascade Meadows LLC is promising the San Juan County Commissioners that Grizzly Peak will maintain all parts of the development until a special district is formed for this development?
you're,
Action, Your Honor, that's not what this says. It says there's no HOA as part of the development.
Mr. Detsky?
It says, currently, the public utility will maintain all parts of the development.
I'm sorry, where does it say that at this one?
It's the next
Yeah,
line.
Okay. And then what was the question?
So as part of this application for Cascade Meadows, are you, Mr. McAlpine, is it your testimony that Cascade Meadows has represented to the San Juan County Commissioners that Grizzly Peak will maintain all parts of the development of Cascade Meadows until a special district is formed?
I stand by this statement. But again, we've talked about what Cascade Meadows could be, but it is not today. It is not a development. It hasn't been fully approved. It may never be built. It will unlikely be built before there's a special district in place. And if it were built, you asked about the tap fees. They would more than cover any maintenance of those roads. And if it were built, the utility would take ownership of all of the infrastructure there. So I stand by number 8, and it has nothing to do with our current rate case request.
You also testified that the tap fees could be used to repay the loans, didn't you?
Yes,
So the tap fees would both pay for the loans and pay for all the infrastructure and maintenance of this development. Is that your testimony?
it says that the public utility will maintain all parts of the development. So the tap fees would, depending on how they're allocated. You can't allocate them everywhere, but they could be allocated to pay for loans. They would be allocated to pay for any utilities that were in place that needed maintenance. It says nothing about purchasing them.
Okay. Can we scroll up to page 25 of this document? Thank you. You see where it says district formation?
Yes,
And it says Cascade Meadows has engaged a Colorado law firm that specialized in district formation to assist with evaluating and preparing the necessary filings. Do you see that?
yes,
And it says the work is underway. Do you see that?
yes,
And it says that a special district proposal could be submitted for the county consideration later this year. Isn't that correct?
yes.
Can you please scroll down to page 49 of this document? This is a memo to you, correct, Mr. McAlpine?
Yes,
It's from your counsel, Mark Davidson, correct?
yes,
And it is regarding a public utility versus special district compare and contrast. Do you see that?
yes.
Can you please scroll to page 71 of this document? And this is one that shows Cascade Meadows LLC, and it shows you as the registered agent. Isn't that correct?
Yes.
Okay. You can take this document down, Ms. Federico. Earlier, you and I were talking about projects in process, and you were talking about the loans. In both of these contexts, you mentioned special district matters. Do you recall that conversation?
Yes.
Is the special district matters that you were talking about regarding forming a special district for Cascade Meadows?
No,
Is it performing a special district for Cascade New Vision?
yes,
So Cascade New Vision and Cascade Meadows would form two special districts? Is that what your
No.
testimony is?
no.
What is your testimony?
What's your question?
What are the special district matters related to with regard to Cascade New Vision Special District and Cascade Meadows Special District?
Well, Cascade Meadows, you're taking a question that was given in isolation from the Planning Commission. Do you have an HOA? Will you form a special district? And we answered that in that context related to Cascade Meadows, but the formation of the special district would be for the benefit of the utility.
I see. So this special district packet, it looks like you've hired architects, engineers, and lawyers to work on this. Is that correct?
Correct.
You've done wetland surveys and mitigation. Is that correct?
We've not done any mitigation. We've done wetland surveys, and we have conversations with the Corps of Engineers.
Traffic studies, have you done those as well?
Yes,
And this looks like a lot of work, but this is not your first attempt to develop some of the 44 acres that Moorhead Property 1 purchased, is it?
no,
Isn't it true that you litigated against the association regarding a different proposed development project
yes,
at Cascade? And that development was not successful, correct?
we dropped the litigation.
Okay. I want to take you all the way back to the profit and loss and balance sheets. And I want to go back to the investor summary of the use of monies lent from CitySculpt. And this is at Hearing Exhibit 2-10. So this is WB2.
Sorry, that's 300 attachment WB2.
300, correct. Attachment WB2, page 25. I want to, sorry, 25. Was that wrong? Oh, I'm sorry. I got the wrong page. Page 14. I'm sorry. So I see here engineering expenses, $398,000 since 2021. Do you see that?
Can we go back up to what started this paragraph?
Sure.
Okay,
Can we scroll back down? I see $398,000 in engineering expenses since 2021. Do you see that?
yes,
I see a line here for legal title work. That's $108,000. Do you see that?
yes,
But you testified earlier today that Cascade owns no property, correct?
it owns no real property, correct?
So this is title work for some other real property then, correct?
No,
It just did random title work?
didn't do random title work. If you're going to lease a piece of property, you'd want to validate the title.
So it spent $108,000 over 4 years validating title to its lease?
I don't know how this got characterized, but legal title work could also be the exploration of water rights, etc.
Mr. McAlpine, this is your characterization and your discovery response we're looking at.
Right, produced by our bookkeeper, so I don't know how she allocated the cost there.
Finally, let's go all the way back to the projects in process. We talked earlier about the projects in process that had been discontinued or abandoned, correct?
Is there an exhibit for that?
Yes, that's the CLM 10. Would you like to see it?
Yes.
Can you go up to page 3 and scroll down to the bottom of this page? Oh, I'm sorry, there's one more page up. Thank you. This is the portion of the projects that did not advance to construction and were deferred indefinitely. Do you see that?
Yes.
Could the projects that were in process and that were abandoned indefinitely be the other development project in Cascade Village that you say you discontinued the litigation on?
No.
No. Could the extensive engineering and legal expenses you've described as related to the utility be instead related to the Cascade Meadows development?
No.
Thank you, Your Honor. I have no further questions. I got hour and a half.
Thank you. Appreciate it. I personally think right now would be a good time for a short break. However, Mr. Larson, I defer to you if you want to, and others, but I wanted to get your input, Mr. Larson.
Yes, thank you, Your Honor. I'm fine with a 10-minute break. I should have a much shortened cross for Mr. McAlpine following that. So just for the record.
Great. Well, why don't we come back at 2:50, everyone? So until then, we'll go off the record and I'll see you soon.
Hey, Charles, it's Mark. So we are going to get
Tracy, are you set?
Yes, I am.
Great. Okay, let's go back on the record. And where we are is we're going to have Mr. Larson. It's your opportunity to do some cross. Thank you.
Thank you, Your Honor. Good afternoon, Mr. McAlpine. We met before. I'm Justin Larson. I represent trial staff in this proceeding. I work at the Attorney General's office. I realize you've already been up here for a very long time and have covered quite a lot of ground. So I just have what I hope will be a relatively brief series of questions for you. And I want to start by maybe just broadening the aperture a little bit to what the company is actually asking for in this case. And I think to sort of level set, I want to just start revisiting the timeline of your ownership of the company and kind of going through to how do we got to where we are today. So you purchased this utility approximately 5 years ago in 2021, correct?
Yes, and again, I didn't purchase it. I'm a member of an LLC and I'm the manager.
Sure, understood. So the entity for which you are a manager purchased this in 2021.
Yes.
And since that entity took ownership of the utility, the utility's first attempt at seeking a commission approval for a rate increase was that prior advice letter proceeding that you mentioned in your direct testimony, right? That was about 4 years after after the company purchased the utility.
Yes.
And that prior advice letter proceeding, and that's 25AL-0160W, that was filed on April 7th of 2025 and then withdrawn on April 29th, 2025, right?
Yes, I take that for granted. I don't know those dates.
Sure, and no reason to dispute that though. That's
No.
approximately when it happened. And so that was about little less than a year ago, or a little more than a year ago.
Yes.
Now, the present application proceeding that we're talking about today, that was filed, again, any reason to dispute, September 22nd, 2025.
No reason to dispute.
And so that's about 5 months after the company withdrew the prior advice letter filing, right?
Yes.
And wouldn't it be fair to say that aside from changing the form of the advice letter filing to a simplified regulatory treatment application, the actual evidence and financial information that was provided with those two filings didn't really change much?
I think that's accurate. Yes.
For example, the company didn't get its financial or accounting information audited during that 5-month period between the two filings?
No, the company's never been audited. We are in the process of trying to find an audit firm now, but it has never been audited.
But the financial information that the company has provided has evolved, for lack of a better word, throughout the course of this case, has it not?
It absolutely has. I think we're thankful for the association of asking certain questions because it made us realize we needed to relook at some of the presentation. So yes, it's definitely evolved.
Okay, and you just mentioned, and I think you mentioned with Mr. Detsky as well, that the company is thinking now about getting their financials audited.
Yes. We welcome
Now,
firms, by the way. It would
sure.
help.
Sure. So turning to the information that you provided in this proceeding, we'll just start with the original application. Can we pull up attachment 4 to hearing exhibit 102? Now, this includes pretty much the full extent of the financial information that the company made available to the parties in the commission at the time that you filed the original application in September, right?
That sounds accurate, yes.
And correct me if I'm wrong, but this is also the financial information that your engineering consultant, Right Water Engineers, used as its basis for the most recent document you provided from them with your rebuttal testimony. Is that right?
Yes, I'm wondering if the document on the screen is pre or post restatement by LBJ.
This is pre. This was the document that was filed with the original application.
Yeah, so there was some alteration adjustment from the accounting firm based on the GAAP principles, but yes, this would be the same body of information that Right Water would also be looking at.
Now, you stated in your direct testimony and have since stated elsewhere in this proceeding that the company is in a pretty poor financial situation, right?
Uh, yes, we inherited a company that was in a distressed situation with really no books. We had to gather what we could from public filings, and we've been really piecing it together since while trying to run the entity. So yes.
So the entity has been in a distressed financial situation for the entire 4 years before you filed that initial advice letter filing.
Yeah, and decades before that, yes.
Now, wouldn't you agree with me though, like looking at this document that was filed with the original application, a neutral party looking at this wouldn't really conclude that the company is in a financially difficult situation. Is that fair?
Yeah, I think it was misstated, and that was why we asked LBJ to get involved and restate it. And it became evident that our internal bookkeeper just did not allocate certain things, that she was working on more of a cash base rather than accrual. So yeah, and certainly my apologies. We should have reviewed this closer before it was originally filed, but yes.
No, fair enough. But so let's go to the restated then. That will be, I believe, the first version of it is attachment DD1 to staff witness Depue's answer testimony, which is hearing exhibit 200. We can pull that up. And so this again was provided to the parties as a means to try and clarify that prior document about a week before answer testimony case, right?
Yes, if this is the last, I checked with bookkeeping on one of our breaks, and there's two documents dated February 13th. One of them was considered draft, and the other was the final document.
Okay, and can you tell me where the company indicated that this was a draft version before it provided this to the parties in discovery?
It was, if you go to the bottom of it, there's an unsigned version. I think that staff just gave everything that they had, but the first LBJ was sent to us unsigned, which would indicate draft form.
Now, and as you mentioned, there are two different documents dated February 4th. Actually, and Ms. Federico, we can take this out. I don't think I'm going to ask any specific questions, but we might bring it back up if we need it for rebuttal or for refreshing. Now, as you stated, the company provided another version of this, also dated February 13th, with your rebuttal testimony, right?
Yes.
Now, looking at both of those LB&J documents, you'd agree that they paint a very different picture as to the company's financial state than the financial documents that we looked at in attachment. They were sent as attachment 4 to the original application.
I would agree that they're the accurate picture.
But it's very different. right, from the original application.
It's certainly changed from what our bookkeeper had done. Yes.
And in fact, wouldn't you agree that like taking these the financials and these LB&J documents at face value, they wouldn't the rate increase that the company is requesting in this case actually wouldn't be enough to cover the company's losses, right?
Yeah, we're looking for this rate increase for a point in time to operate things now. It is not enough for the future, but hopefully with some growth that it would be sustaining. But this is a one-time request.
Apologies. So, well, you do understand to that what you just said about the one-time request. You do understand that you're also requesting that an annual adjustment, right, be applied.
Yes.
As part of your application. So these once the initial rate increase would, if it were approved, would be annually adjusted as well. It's not just a one-time, right?
Yes, and we're trying to get in a category which would be more of a standard operating procedure. We've learned in the process since 2021, there's no entity like Grizzly Peak in the state of Colorado or anywhere else that we can find that is a privately owned public utility that's treated like a very large utility. So part of that, and it does tie back to that annual adjustment, is let's get this operating like a normal business so it doesn't keep falling behind.
So, and Ms. Federico, we can take this down. Now, just based on our discussion there, it's true, isn't it true that like neither set of financial information that's been provided, whether it's the LB&J version that was provided later or the financials that were provided initially with the application, neither really explains the actual amount of the rate increase that the company's asking for here, because the initial one doesn't show a company needing a rate increase, and the second ones didn't show enough that it would be enough of a rate increase.
Well, it would. We think that the second one would be enough of a rate increase that with other anticipated growth, but it deals with us again at a point in time. The second one, and I would say the only factual set of documents that we have, it's regretful that we have conflicting data, but the second LBJ, why we went to a third party unrelated accounting firm, was to give an accurate picture. But we believe that that would create a sustaining entity for what it is today.
But that the LB&J accounting documents, they didn't audit the underlying information, right? They just relied on the information as you gave it.
Correct.
So while I understand you've given a lot of explanation and testimony in here about why the company needs a rate increase, the company's never actually provided like a concrete calculation or explanation for how you arrived at the specific rate increase amount you're asking for. Isn't that fair?
Well, respectfully, I thought that we did that with the help of Brightwater in their analysis.
You're talking about the Brightwater analysis that was submitted with your rebuttal?
Yes.
That report also relied on the financial statements and information, as you had discussed with Mr. Detsky this morning, that the company provided to it, right?
That's true, but I think the discrepancies, the things that weren't provided in the original financials were the things that were being accrued. The actual income and expenses stayed the same throughout the process with the anticipated expenses. So Brightwater got the data that they needed, and there's been no discrepancy of that data.
That Brightwater engineer document also didn't provide any itemized costs or like didn't put in like the useful lives of any of the assets that were being discussed, did it?
I can't quote the Brightwater document page by page, but I frankly assume that they were working on sort of a programmatic filing. So if we didn't specifically ask them that, they may not have done that.
So despite the evolving nature, I think we agreed on that term, of the financial information that the companies provided throughout the course of this case, the companies never sought to actually change the requested rate amount or the requested capital reserve account. I think it's $18 fee, right?
That's correct. We decided to stay with the same rate.
And sticking with that major capital improvement fund account for a second, you stated in your rebuttal testimony that you understand that if the account were established, you would need to get commission approval for expenditures from the account, right?
Yes.
And you stated that you agree that this oversight approach is appropriate, right?
Yes.
Now, you understand that this would mean that the company would need to provide timely and reliable reporting to the commission.
Yes.
But in that rebuttal testimony, you also acknowledged that the company failed and said that there was no excuse for the failure to actually file its 2023 or 2024 annual reports with the commission, right?
That is correct. That is something we've been learning to do. We were frankly not aware that we needed to. It slipped past us. We have been dealing with a lot of issues here.
I think we lost Mr. Larson.
Yeah, I was just gonna say, it looks like I think he's coming back. Wait, I thought I saw him.
I am
Yep, there he is.
so
There he
I'm
is.
so sorry. I am so sorry. I have no idea what just happened. But it just logged me out and put me back in.
Welcome back.
All right. Can everyone hear me okay?
Yes.
Okay. So now we were talking about the annual reports and so the company only filed the 2023 and 2024 annual reports during the pendency of this proceeding when the parties had pointed it out to them.
Yes. And prepared.
And
25.
And the financial information that was included in those reports, again, is, I think you would agree after discussing with Mr. Desky this morning, that also is a little bit different from some of the financial information that we've seen in either the LB&J documents or the original application file, right?
I would agree it's different, but I'm not sure that that's actually a problem. That I think there is some mix of accrual-based and cash-based accounting that's happened, and it looks like that there may not be reconciliation of some of the loan amounts and pay down from one loan, paying the other lower interest rate. We'd arbitrage that debt. So I'm not sure that it's a mistake. I think it may look inaccurate, but it may actually be very accurate. And I will point out too, 2021, we were dealing with half the data that we really needed to make the report, and 22 were adding up. And I think we've got more into 23 and 24.
No, thank you. I appreciate it. But, and I'll turn to something else here because I understand, but maybe just a few more questions here on, there was a long discussion with Mr. Detsky about this sort of complicated web of entities with sort of related or shared ownership. And you would agree with me that it is a little bit complicated. It's hard to follow exactly where one ends and where the other begins, right?
I think when we're given the chance, we can uncomplicate it, but yes, I understand it could be complicated from the outside.
Well, the company has never provided like a organizational chart that shows how these things were related, right?
Well, again, we're working on a rate case and operations of Grizzly Peak. Some of those entities are not, we don't have majority control. We don't have authority to disclose their personal business.
Now, this morning, and I want to make sure I get this right. Now, during Mr. Detsky's questioning, you initially said that Cascade and Grizzly Peak maintain different books, but then later corrected yourself to say that they do not, or am I mixing that up?
That you're mixing that up. The initial question was, did I think there were two sets of books? And I initially answered no. And then on one of our breaks, I checked with the bookkeeper and she said, yes, of course, we maintain different books because they're two different entities. So I misstated the first time this morning. Again, I don't physically do the bookkeeping myself. So some of that is I answer to the best of my knowledge.
Now, can we pull up attachment DD2 to Dr. DePue's answer testimony, hearing exhibit 200? Thank you. Now, in this discovery request, actually, can we go down to page 5? Okay, so looking at the question is staff asks, has Cascade developed a cost allocation manual or other means to segregate costs between Cascade's regulated utility business and its other non-regulated businesses? If yes, we asked if you could provide a copy, and if not, we asked if you'd be willing to develop a manual or other means to segregate those costs. And so going down to the response, and I'll just read along with me as I read aloud. Cascade does not presently have a cost allocation manual, but maintains a segregated bookkeeping system in order to avoid cross-subsidization between Cascade and any related companies. Cascade is willing to adopt a cost allocation manual as necessary and will do so within 6 months of the final commission decision in this proceeding. Did I read that right?
Yes.
Now, taking the first part of that sentence, that Cascade maintains a segregated bookkeeping system.
Yes.
Can you give me any specifics? And I think we might have asked for this in discovery later, but aside from like the fact that they are different entities, can you describe or explain what it is you actually do to maintain a segregated bookkeeping system?
Well, they all have their own bookkeeping system. They have independent ownership groups with various interests in the LLCs. Cascade here is being used as somewhat of a generic term, but Cascade New Vision only owns the utility. It doesn't particularly do any development type work. There are other entities with the Cascade name that are wholly owned from other investors and a mix of that. So we as a management company provide bookkeeping services to each of those, and each of those would get an annual report that was filed. Each of those would get private profit and loss statements, tax filings, et cetera, et cetera. But those are wholly unrelated to the business that Grizzly Peak or Cascade New Vision is doing.
But as you said in this discovery response, the company doesn't have a cost allocation manual that lays out how things are actually done. And is that right?
Well, yes, but the question was related. It appeared to be related to non-regulated businesses like real estate development. And our answer in thinking through how to answer that, well, we don't do those. We just provide water and sewer services. That's it. So there are no activities of what this is referring to of Cascade.
So when you say in the second part of that response that the company is willing to develop a cost allocation manual within 6 months of the final decision, you're essentially asking this ALJ and the commission to approve the company's request in this case and take it at its word that it's going to segregate the bookkeeping, right? Because without a cost allocation manual, I don't know how we can
Well,
say
again,
anything.
we're a tiny utility. This utility operates strictly for water and sewer services. If there's some allocation that you want us to do, we're happy to do it, and that's what we were trying to convey. But we don't operate in any of those other non-regulated businesses. And so the only thing I guess could be, and frankly, I'd probably have to ask the attorneys about that, but the pursuit of a special district for the benefit of Grizzly Peak or Cascade New Vision could be segregated, I suppose. But otherwise, it doesn't have any of those non-regulated businesses. So we're trying to make sure. You asked if we were asking the commission to take our word for it. No, but we're asking the commission to be very conscious that this is a water and sewer entity, and that's what it provides, period. There's an awful lot of discussion of other development related entities and other lands, but they're not germane to this rate case.
We can pull this down as Federico. Now, the last thing I want to ask you about is this loan that you were discussing. I mean, there were several loans that were discussed in that prior discussion, but I want to ask about the Alpine Bank one. And I don't think we need to pull it up, but that loan is dated December 1st, 2025, right? So that loan was taken out during the pendency of this case.
Yes.
And it was disclosed in response to discovery to the association after rebuttal testimony, right? Now, as the owner,
I'm
or
sorry, I did not
rather-
hear that answer. I did
Mike?
not hear his.
Yes.
And I just want to be really clear about this because it wasn't clear from that discussion. As the manager of the utility, can you tell us specifically what the proceeds from that loan were used for?
We use that to pay engineering and legal and planning bills predominantly.
Can you tell us about any specific assets or any specific, I mean, anything more specific than what you just said would?
Well, we've got a bucket full of issues. You know, we've had to investigate what our water rights were.
No, I understand, but I want, as the manager, there had to have been an impetus for why you took out that loan, right?
Yes. And I'm certainly trying to answer that question. We've been looking for loans for this entity for a while, but the but for is we would not have had funds to pay our attorneys. We would not have had funds to pay consultants to pursue this rate case, for instance. But beyond that, we've had to investigate finding the water rights that we were going to drill for new wells. Are they fully approved? We've had to investigate based on what the state has told us that we have to do something about our lagoon plant. We had to investigate the alternatives between upgrading our current system or connecting to a neighboring system or any other alternatives. And it's significant engineering work that's gone into that. So it's not just been, there's no slush fund here. I mean, this is, if people think we're somehow self-benefiting, this is the worst investment ever. And so, but I did agree to personally guarantee that debt on behalf of the borrower who is not Grizzly Peak. And so Grizzly Peak was the beneficiary of those funds. But if you're looking for dirt moving on site or some new pumps that we put in place, that's not how those funds were used.
All right. No further questions from staff. Thank you for your time, Mr. McAlpine.
Mr. Larson, I do have a few questions for you, Mr. McAlpine.
Sure.
Pull them up here. Many of them have been addressed. So I forgive me if I sort of choppy in my questions for you. The first question, I apologize because I just am unclear. How many owners does Cascade New Vision have?
I believe I'm the manager of that entity. I'm not 100%. I need to check the cap table. I believe it would be 2.
And do you know their names, who they are?
Uh, no, one would likely be Moorhead Property One, the majority owner. And then City Sculpt, we may have a fragmented interest, which we often negotiate within our management contract.
Okay. And so the owner, go ahead.
I didn't mean to interrupt you. There could be other owners if Moorhead Property One has invited other people into the entity that we wouldn't know about.
And by we, you mean City Sculpt?
City Sculpt, sorry, yes.
Okay. And then just a question about the total number of your accounts. Do you have equal sewage accounts and water accounts, or are they different? The number of accounts that you have?
I believe that they're the same.
Let me just sort of kind of high level relative to the number of accounts in the testimony, and I'm not going to pull up any testimony at this point. You reference having about 500 customers. Can you explain the distinction between accounts and customers?
I'm not sure where that reference is. I typically say we have slightly less than 200 users, and I have to admit there's a section we employ a company to do all of our billing, and they can tell me the exact number of users, but we also provide some services to the Colorado DOT. They have kind of a work encampment just north of us, and so I'm not quite sure how to document that number of users.
Okay, gotcha. So, but it could be an individual who uses the facility could be considered a customer.
Yes, but it's all to units of
Okay.
one way or another to individual units.
Okay, let me see here. Just going through my questions here. What is regarding the lease, the land lease, what is the current monthly payment for that lease?
It's accrued. I believe it was 12,000 a month. I don't have that lease in front of me.
Okay. Do you want me to, should we pull it up?
We can pull it. It probably has the monthly payments on that.
It's hearing exhibit 300 WB5, I believe. Ms. Federico, if we're able to get that.
I can just do the math. Sorry, it's 15,000 a month. I know the annual lease payment. It's 15,000 a month.
Well, if it does say there in paragraph 3 that it shall increase by 2%. Is that increase not occurred?
We have not employed that increase at all. In fact, the payments have never been made on this land lease.
Okay. Okay, thank you. And Ms. Federico, that's all I need for that. Thank you so much. Going through, apologize again, a lot of these have been, Mr. Larson covered a lot of what I was going to ask about here, so just bear with me. Okay, Ms. Federico, if we could pull up hearing exhibit 300 WB2 and go to page 9. I have a question about the calculation for the rates. Is that WB2? Oh, okay. Yes, I apologize. Go to page 9. Is that what you? Okay. Could we go up? I feel like this is up a page. My apologies. I will tell you, I know you don't have it in front of you, but I'll tell you what I was looking for. And I apologize for my error here. you responded to a question related to the calculation for the requested rate increase. And Cascade said, quote, "Not sure how the numbers were calculated by the prior CFO. It was based on rate increase to cover ongoing operations as well as to support investment for updates to systems and facilities." And with regard to that piece about investment for updates to systems and facilities, how much of the rate increase that you're proposing would be allocated to those sorts of expenses? The breakdown between operation costs versus investment.
I don't know that we've broken that down per se. We did ask for the future investment or capital fund, which would be the majority of that. But the intent, the only way that this entity ever survives is to grow, and it's going to have to pay initial soft cost to facilitate that growth. And that's where that was meant to be.
Okay, I appreciate that. All right, regarding the system development charge, and we don't need to pull it up. I think you'll be able to answer this. In your direct testimony, you say, "We," in quotes, "have long-term plans to serve additional customers when we," again, in quotes, "fully build out the Cascade Village development." I take it that is not Cascade New Vision, the utility, who is going to be building out the development. Is that correct assumption on my part?
That is correct. That they're individual landowners for each parcel that encompasses all of what is called Cascade. And that all survives under I think it's 1996 master plan that was approved for a lot of units. I couldn't tell you the exact 400 some odd total units. And so we collectively, representing all the landowners of those individual parcels, everybody eventually intends to grow and expand. Now, the one I want to make sure I answer this correctly and as detailed as possible. So if you just bear with me, the intent is for the utility to own the infrastructure once it's developed, and the special district creates a mechanism for that to happen. And that's normal in lots of states. It's normal in Colorado and all over, but the utility would take ownership of those infrastructure investments, water, sewer, roads, and you charge a fee to that new section of developments for the maintenance of that. None of that would flow back to this operations that we've posted here or this rate increase. That would all be for new users and new sections.
Okay. Okay, thank you. I appreciate that. And how have you assessed, just big picture, about whether customers would be willing to pay that $25,000 charge? How did you come to that number?
I'm sorry, the $25,000 charge?
For the system development charge, the proposed system development charge?
I'm trying to think of where that category is, and I'm not sure if I can ask Mark to help me out. But
the tap fee
the tap fee, yeah, sorry. That is typical for a builder to pay when, and again, it's not relevant to this rate case or these operations of what Grizzly Peak or Cascade New Vision is now. It is not part of this rate case. But if, for instance, Cascade Meadows does get fully approved, and if they start to build out, when a builder builds a home, they will pay a $25,000 tap fee plus the school fees and workforce housing fees to the county. It's pretty normal in the building process.
And how did you come to the $25,000 amount?
We compared neighboring systems. Purgatory is the closest system to us, and theirs is actually substantially higher, but we thought that was kind of a good place. It's a rounded number, no doubt. There's no scientific calculation to that. It's what you think the market will bear.
Okay. Thank you for that. And I just had looking, just making sure I'm looking at this. So regarding the major capital improvements, in your direct testimony, you refer to $21,000 in repairs and upgrades that I believe were related to a water main break.
Yes.
Have those fees been paid? And how was an extreme one-time surcharge is referred to in your direct testimony imposed? Or how did Cascade cover those fees, or have they been paid?
The costs of those repairs have been paid, and it was paid through these loans. There's been no surcharge.
Okay, so in your direct testimony, you refer to wanting to avoid extreme one-time surcharges in the event that there's a catastrophic event. So, but that is not how Cascade has historically handled that.
Yeah, we're in an unsustainable situation now. If there's another pipe break or something like that, or something of greater expense, we either have to borrow the money from somebody or a bank or whatever, or we have to charge the owners. We've been trying to avoid charging the owners, so we have been borrowing money. But I think that borrowing, and maybe as the numbers are starting to show, is unsustainable.
Okay. And then similarly, talking about the major capital improvement request, forgive me if I didn't see this. What will it cost Cascade to upgrade your system to comply with the new federal requirements?
Well, the requirement that we're most focused on, unfortunately, the federal requirements seem to change with the wind right now. But the one that we're the most focused on is the state requirement relating to upgrading we have what they call a lagoon system, where you'd see an open pond. Either upgrading that lagoon system or dismantling it, and we would effectively join the system next door, which is, again, purgatory. And we're in the process. The Right Water report to evaluate those alternatives was part of the discovery that we produced. No decision has been made, but it's a big number. And I would also point out, Right Water, I think that number could come down considerably with some significant negotiation with the neighboring facility. But right now they want to charge every owner at Cascade, for instance, a new tap fee, where even people that are getting sewer today would have a $25,000 immediate pop. That seems unfair to me. So we've been trying to work in a way to negotiate those things down. But that's the biggest, and I don't think I answered your question. The numbers that we've heard are in the neighborhood of $30 million.
Okay. All right. Thank you for that. And I'm not sure you'll be able to answer the rest of these questions, but since you're the Cascade witness, you're the person to ask. Regarding, I believe is it CLM 8? It's the engineering report. I'm wondering if we might be able to pull that up.
I think it's CLM 9, Your Honor.
CLM 9, okay. And actually, we don't need to pull it up, actually, Ms. Federico. I think I could just ask a question. In the March report, the engineers say that they adjusted the 2024 cost estimate to $2026 by using the engineering news record construction cost indices. Do you happen to know which month in 2026 and which city they used for their indices?
Oh gosh, no, I think Right Water would be the only ones to know that. That's internal
Sure.
work.
Yep, I just thought I would ask since you were here 1 second. And with regard though to that report, it assumes 10,000 gallons per month usage per customer. And that seems high in light of documents that were filed into the case that say the current units use less than 120 gallons per day, which would average 3,650 gallons per month per account. Do you know why 10,000 gallons per month was selected as the metric?
Dave Marsa may be able to answer better than I, but I'll tell you what my belief is in discussions with Right Water. They're held to certain the gallons per user calculations, based on their charts, I guess. But also Cascade has multiple sites that would not be single or multifamily residential. They may be hospitality or some commercial at some point in the future. And I think, and again, I'm speculating, I think that that's where those numbers come from.
Okay, appreciate that. And I think, okay, I think those are all the questions I have for you. So thank you for your time. I appreciate that. I have no further questions for you. We are coming up on, I think we've been going about an hour and a half. Mr. Davidson and parties, did you have a preference for how to proceed at this point? I don't know how much redirect you have.
I have some, Your Honor, probably maybe 20 minutes or so. And then Mr. Marsa is available. I think given an hour, we could probably finish his testimony based upon the estimated times that staff and the association have listed in the pre-filed document. And I think that might get us to the end of and any questions you may have would get us to the end of this day, and we could start in the morning with Mr. Burkett and then Dr. DePoo.
All right, well then I propose we go ahead and have you do the redirect now. Does anybody object to that? And that includes you, Tracy.
Yeah. Most important person.
Yeah. All right, I think taking that as no objection. So all right, let's go ahead and proceed. Thank you.
Thank you, Your Honor. I'm going to go just in reverse order with you, Mr. McAlpine, for just a moment here. In your conversation with the ALJ, you referred to the term soft costs with respect to future development at the utility. Can you define what you mean by soft costs with respect to this utility?
Yes, I'm sorry, it's kind of industry jargon, but it wouldn't necessarily be with respect to this utility, but any anticipated capital improvement would have a section of its costs that were what we would refer to as soft costs, being the design, permitting, engineering, where the hard cost would be sticks and bricks, if you will.
And as I take that answer, the soft costs would precede the so-called hard cost sticks and bricks because you'd have to design and engineer any particular system. Is that what I'm understanding you to say?
Yeah, in this case particularly, in a typical real estate development project, you may have the hard cost of land up front, but you're right. The soft costs would typically precede all of these other things that eventually will happen.
Okay. Then I have, I think, just one question about something Mr. Larson, staff counsel, asked you. Ms. Federico, could you pull up Exhibit 103 Rev 1 CLM 9, page 6, please? So this isn't a great exhibit, or excuse me, attachment, but I wonder if you can turn it. The ALJ had asked earlier at the outset, I guess, whether we could provide an executable version of this document, and I haven't had a chance to check with Right Water yet. But for purposes of this question, Mr. Larson asked you if there were any representations of the life of assets to be implemented, the useful life of assets for future development. And I don't know if you've seen this, if you can read this document, but to me, it looks like their analysis for Right Water went out to about 2050, 2055 maybe, for future development and needed repair upgrades to the system. Is that correct?
I cannot read what's on the screen, but I do remember that we had significant conversation with Wrightwater about expected useful life of certain upgrades. So yes, and I appreciate I did not answer that question properly because they certainly did produce this.
Okay. All right, now let me go back to Mr. Detsky's cross on behalf of the association and take you back to this morning. Sorry about that. I think I can move through this fairly quickly with you. One of the aspects of the utility operation here that I think you've described a couple of times, but let me make sure, is that CityScope acts as the manager for the utility operations and you in that capacity. Do I have that correct?
That's correct. We being members of CitySculpt share the management responsibilities, but ultimately the buck stops with me. But we manage the utility here. We manage a variety of the LLCs for future development, as we do across the country, by the way, where we may own a small portion of the projects, but we may just be acting as a fee-based manager. So in this case, I was trying to make sure I answered properly that apparently there's some misunderstanding that I own everything, and that is inaccurate. I am the manager for these entities. So when we have entities that enter into agreements with each other, we as the manager have pre-discussed those agreements. For instance, a land lease where you have or a loan where you have a borrower and a lender. We've taken our management responsibility to both parties and said, should we execute this document? So members of CitySculpt can be the signatures on the same document, but they represent two different entities. It is not self-dealing for CitySculpt.
And in that capacity, does CitySculpt also seek financing for the utility on occasion?
We do in this case, and in all of our management responsibilities. If any of the entities need loans, we evaluate whether they're capable of achieving a primary loan with a typical bank, or if there are loans available at state or federal agencies. And in the case of, again, as you know, Mark, but for the whole audience, Grizzly Peak is a very unique asset, the only privately owned public utility. And it was designated before it was bought as a for-profit entity. And that has prohibited from borrowing money from typical state funds that utilities borrow from. And it has fairly low revenue and fairly low assets, so it's not a good candidate to borrow from banks. And so we've had to facilitate loans to Grizzly Peak to keep it in operation and to hopefully progress it forward. And lastly, I know I'm overstating this, but we did inherit an asset that, it was an old dusty car in the bottom of a garage that nobody had touched for a decade, and there was an awful lot that had to be done to it. And so that's where all these, needs have come from, along with typical operations.
We had a long set of questions with Mr. Detsky about the financials presented by the company in this proceeding, and you've addressed that earlier. But as far as the sort of end report here, the Wrightwater Engineers report, you had mentioned, I think, was based on the profit and loss restatement in CLM-10, the second of the two LB&J accounting reports that you mentioned earlier. Did I have that correct?
The Wrightwater was certainly based on all of that information that we provided them. I think I was trying to make the point that they were interested in typical expenses of operation, income and expenses, as well as future needs, and that generated theirs. I think, in other words, the discrepancies in the earlier reports and the later LBJ report did not have a drastic effect on Wrightwater's work product.
And is the CLM-10 attachment LBJ report the, I'll say, last of the financial analyses that the company presented in its case here?
I believe so. That should be the full and corrected version.
Okay.
And I'll take responsibility. I think knowing that the entity did not have a lot of funds, we tried to do as much of the bookkeeping in-house as possible. And I think that in retrospect, we should have employed LBJ from the beginning.
And I know you mentioned a couple of times with Mr. Detsky and I believe Mr. Larson as well, that the company's books have not been audited for purposes of this proceeding, correct?
That is correct.
That said, did the company provide the best version of the financial information it had at the time in order to support its case in this proceeding?
Yes, with a couple of oversights. I think there were things that my observation is potentially in bookkeeping, we mixed some accrual and cash base, and that gave an inaccurate reporting. But yes, we've attempted all along to provide the best accounting that we could, and it's been a shoebox full of receipts. Basically, it's a mess.
You had a conversation about projects in process. Do you remember that discussion that you had with Mr. Detsky earlier today in general? And as far as projects in process, he talked to you about things that had been abandoned. You addressed relocation costs, upgrades to systems, future upgrades, et cetera. Are the projects in process, does that also include operational maintenance for the facility?
No, but I do want to point out that projects in process is an accounting terminology that our bookkeepers use. And LBJ may have just truncated some of those. The proper accounting, GAAP accounting allows you to take losses in some years rather than others, et cetera, et cetera. No project, to my understanding, have we started anything that's been fully abandoned. We have, as we did in the rate case, we have attempted some things and then realized we didn't have the full data and come back and gone to it. We think that there's a variety of other projects on behalf of Grizzly Peak that'll take place in the future.
And since you acquired the utility back in December of 2021, I think, at least as I count, you've had at least 3 CFOs since that time, leading up to Mr. Wolfram today.
Well, I think it's 2 and an accounting manager. Mike Miller retired a year and a half ago now, I think, and Mr. Wolfram is our CFO today. And you may be referring to Nick Kraus, who was with us for some time, and he particularly shepherded the utility assets for a bit. Just 2 CFOs.
Oh, okay. Maybe I got the title from. To just clarify one point, the Mike Miller Indeed page we saw today, I think you said it's the first time you've ever seen that. Has Mr. Miller maybe not quite updated his Indeed page?
I think it was LinkedIn,
Or LinkedIn.
and it is the first time I've ever seen it. And Mike is, I think he's fully retired, but does some consulting work, so that probably helps his resume a little bit. So I don't have a problem with it, but it is the first time that I've seen that.
And he is no longer the CFO at Cityscope.
He is not.
We also had a conversation about the simplified regulatory treatment, or portion of that we're asking for, and the annual rate adjustment mechanism. You generally remember that conversation with Mr. Detsky?
Somewhat.
And that, if I think it's right, if you may recall, that adjustment mechanism uses a prescribed formula in the commission's water rules. Is that your understanding?
Yes.
Is it possible that the annual application of that adjustment, instead of, I think what everyone's assumed would result in future rate increases, could result in a rate decrease depending upon the components of the formula used?
That is my understanding, yes.
Okay. You also indicated that this case, in your opinion, is a quote normalization, close quote, of rates for existing service. What did you mean by the use of that term?
Well, again, I guess I'm harping on this, but Grizzly Peak is such a unique entity. I've never managed anything like it, and I've been involved in water and sewer utilities at various parts of my career. But because of the way Grizzly Peak is regulated, it has to fly a Boeing 737, and it has enough users to work on a Cessna. So we're trying to normalize it down to the business that it is, if that makes sense, and run it like a smaller business would typically. Again, the reflection of these loans that have been made to the company, there's been a variety of consultants and, again, soft cost to try to live up to the public designation.
All right. You also spent quite a bit of time going through a series of promissory notes with Mr. Detsky.
Yeah.
And if necessary, we can pull up one of those as an example. But as I reviewed them when you were being cross-examined, there's a provision that wasn't mentioned in each of those promissory notes, aside from the last one, the Alpine Bank one, but the ones that preceded it, that indicates the loan is to be repaid in 6 months or subject to permanent debt financing being obtained. Do you remember that provision in those promissory notes other than the Alpine one?
I do.
Okay. Has permanent debt financing been obtained for any of those loans, or are they just moving forward without being called?
It has not. Again, part of another investigation and project in progress process would be to turn this entity into a not-for-profit, which it sounds very easy. It's quite difficult in legal and accounting terms to do that. However, if Grizzly Peak were a not-for-profit, it would have the ability to borrow funds needed at a very long maturity date with a very low interest rate. And so those would be considered permanent funds, and it would relieve the related debt that it has now. And I'll also make the point, again, CitySculpt, we manage 40 or 50 projects nationally. Part of our management role is to facilitate funds that projects would need, and it is not uncommon that we go to some other project or entity that we manage and ask those owners if they'd be willing to make a loan, and those loans are always at 8%. And so we facilitate those lending funds from one entity to another, but just because we're the manager of it does not mean that we're self-dealing. We're not the beneficiary of that. So.
Okay. You spent a lot of time on cross discussing various financial issues and accounting issues with respect to this particular utility, but I guess I don't remember a single question put to you yet today about the operations of the utility itself. Why are you seeking the proposed rate change from a utility operational standpoint?
Well, operationally, the expenses exceed the income. It's the basic business question. And so there should be a rate increase. And again, I'll go back to the terminology of normalizing what Grizzly Peak is. It's been, I think, different timeframes have been batted around somewhere between 14 and 20 years since there's been a rate increase. Or anybody's looked at its land leases or any of those things. Again, think of an old car buried under debris in a barn. It has been ignored. And I think even the Colorado State Utility Commission would say that they've had very little interaction in the past decades prior to this entity's ownership. So we're trying to normalize the income and expenses so this can operate like a normal utility business.
And as part of that effort, I think you had you did have a conversation about the potential creation, I should say, of a special district for the utility. What are the benefits in your mind of a special district for this utility?
Well, first and foremost, the special district does have the ability of different forms of debt, both borrowing and floating bonds for future expenses. And those can come at a significantly lower rate than what a bank or individual loans would be. And then special districts also have the allowance to act essentially as an HOA and control the type of development that happens long term. So those are the first benefits we see. And as we speak today, we have hired a firm to pursue a special district for this utility.
Is that a lengthy process?
Yes, there's certainly public meetings and other things. I wish I knew the regulations well enough to quote this, but it's something really strange that there's only a couple of times a year that you can get designated as a special district. It's not like there's a monthly vote. So the paperwork and whatnot is one set of lengthy process. Then there's the public format of why you've got to make your case of why you need it and a vote on that. And then there's I'll use the term a ratification vote with the state. So it is a lengthy process, yes.
Mr. McAlpine, I think those are all the questions I have for you on redirect, unless you have anything you want to add before you're excused in summary.
I think the only thing that I would have to add is that the but for of this utility, has it not been operated the way that we've operated it, it would be in significant despair at this point with no opportunity to grow its way out of it, which we've been trying to create those opportunities. But I understand that no ratepayer willingly wants an increase, but I wholeheartedly believe that this rate case and this increase ultimately helps the owners that are there presently and the future owners, again, get to a normalized situation. The rates there are significantly below what the market is around. So I'll just end with that it's been a strange endeavor, but hopefully we can get through the process.
Thank you, Your Honor. That's all I have on redirect, and we'd ask that Mr. McAlpine be excused.
Thank you, Mr. McAlpine. I know it's been a long day for you, so appreciate your time and being here.
Thank you.
I will propose that we do continue on. I don't know, and Mr. Detsky, I'll get to you in just a moment. I don't know how far if we will be able to complete Mr. Marsa today, but I would like to get it started. I would like to take a bit of a break first, but Mr. Detsky, you go first.
Thank you, Your Honor. Just a couple of cleanup things. First, earlier in the day, when we tried to introduce the notice exhibit, it was referred to that we needed to bring that in as an exhibit as opposed to it being a file. So we've marked it as exhibit 330 in the association's box, and I would ask to move it into the record as the notice that was filed with this case to customers.
Did any party have an objection to that?
No objection, Your Honor.
Great. Okay, yes, we can get
and
that
then-
submitted.
With respect to the demonstrative exhibit, here exhibit 305, we've cleaned it up and put a new version of that in our box. If Your Honor would like to move it into the record for your own review, we would be willing to do that. We'd also be willing to attach it to our statement of position, which I believe you said was 1313, not 30.
Yes, 13, and this would not count towards the 13 pages either.
We could do it that way as opposed to to the record if you'd prefer.
That would be great. Actually, that would be useful for me.
Your Honor, if
yes.
I may address that topic, since I haven't seen this demonstrative exhibit except during cross-examination earlier today, I was wondering if Mr. Detsky, in addition to attaching it to his statement of position could provide a copy to me on behalf of the company for a review.
I think Casey may have something to say about that.
Okay.
That might be why she's raising her hand.
Well, I can add that the shared folder link in my email that I sent out about box.com, there's a link to a hearing folder. The demonstrative is in there. So you can click that link and you can see it and download it, as well as every exhibit that's been discussed about during the hearing today, except for the ones that are already on the spreadsheet. So just so everyone knows, that is in there.
Sorry.
So I was just going to say, my question was, though, am I swapping out 305s or not? I didn't get an answer of if you're just going to attach it to statement of position and I should leave the old version in here, or I just wanted a little clarity on what you'd like me to do there.
Yeah, and Mr. Detsky, that's your call. Yeah.
Yeah, I would say swap it out, because what we did is we removed the highlighting that I had used in.
Okay. That works for me. And did you provide that updated? Oh, you'll upload it?
Yes, we'll
It'll be
upload it.
okay.
I see it. I'll swap it out. And then my last question was that last exhibit you talked about. I just wanted to make sure I heard the number right. 330, right?
330 should be the notice.
Perfect. Thank you.
And since we're talking about exhibits, I have a note to ask about later, and it's CLM 5. And I vaguely remember this, but I don't have specific memory of what there was an issue with. Oh, is that the notice? Is that what that was?
No,
Okay.
CLM 5 was filed last Thursday, and you deleted, or we took those off the record this morning. And then I readmitted just that one in my cross.
Thank you. Okay. All right. So I didn't check it off the list of things to look at, but it has been admitted, you say. And what was
Yes.
it admitted as? What is it now?
306.
Oh, I see. 306. I even wrote CLM 5 submitted last week. Sorry. I just didn't cross it off my to-do list. So now I propose we take a small break and then we reconvene and do as much as we can, but I'm not going to hold parties here past 5 o'clock. So if we break before then and there's a natural spot to stop before 5, that will be okay. But is that okay with the parties?
Yeah, the applicant would appreciate getting Mr.
Okay.
Marsa going, at least see how
Okay.
far we can get and shorten his time tomorrow, because he has other responsibilities.
Okay. And staff?
Yeah, that's fine with us.
Okay.
Thanks.
And Mr. Detsky, are you okay with that?
Yes, Your Honor.
All right. Why don't we do this? Let's take a short break until 4:10. It's okay if you come back at 4:11, but let's take a little bit of a shorter break so we can just get some water and refresh our brains for a moment. But see everyone soon.
Thank you.
Tracy, can you hear me?
Yes, I can.
Great. Let's see. Give people a moment to come online here. All right. Mr. Davidson, would you mind tendering your next witness for cross-examination?
Thank you, Your Honor. Cascade would call Mr. Dave Marsa.
Mr. Marsa, will you please raise your right hand?
Hang on, got to get everything turned on.
Yeah, of course, no worries. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, go ahead and proceed, Mr. Detsky. Thank you.
Thank you. Good afternoon, Mr. Marza.
Good afternoon.
My name is Mark Detsky. I'm an attorney representing Cascade Village Condominium Association. I want to talk to you just briefly today about your work on the water and sewer system. You've been doing this work for both Cascade and New Vision and for the prior owner for a number of years. Is that correct?
That's correct.
Okay. You say in your testimony, the Cascade right now operates on 2 wells. Is that correct?
Majority of 2 wells. It has 2 wells, and then a 3rd well is listed on the state as backup. And we have drilled a 4th well, which is well number 9, but has not been approved to be connected to the system yet.
Okay. And when did you drill that well, number 9?
Was that 2020? It was right as COVID hit, and that's basically what got kicked out. So it was 2020, I believe.
2020. Okay. I wanted to point you to an exhibit, see if you can help me put something together. This is attachment WB4 to hearing exhibit 300, Miss Lynch. And I'm looking at page 33. So, Mr. Marza, the tricky part here is that I don't know if you could recall or take a look at the permit numbers and be as familiar enough to know. But what I have here is the well permit number you could see in the middle, 41823. Does that look like one of the Cascade wells to you?
I could look it up, but yes.
Okay, subject to check.
Yeah, 50827. That would probably be well number 9. Is that the newest one?
Well, if you could scroll to the next page. We got there's 3 total here. This page has got 40663, and then there's one more page, Miss Federico, Miss Lynch. Keep doing that. 48545-F-R. That's like usually a replacement well designation.
Yes.
So these 3 wells, these are ones that are now in the name of Moorhead Property 1, correct?
Correct. Like I said, that's probably the 3 that are listed as active with the state. I'd have to check the numbers with my records, but yes.
And these are the wells that serve the utility, correct? Okay. Thank you, Ms. Lynch. You could take this exhibit down. And so you testified already. I was going to ask you about a new well, but you said you've got one dug as of 2020. You testified about this one line break you had last year before. Is that right?
It's in the fall of 2023. Yeah.
Okay. And I think there was some testimony earlier that was about 21,000 to repair. Does that sound right?
If that's all it was, I thought it was actually more than that, but yes,
Okay.
easily 21,000.
Okay. Any other major breaks since then?
Breaks? No, we haven't had any other breaks. We've had other things happen, but no breaks.
Okay. Have you replaced any big chunks of the water sewer piping?
The manholes on the sewer system, we had to bring those up to grade so that we have access to them to get a cleaning done and
Okay.
to do the inventory.
Okay.
So we
Thank you.
did do some manhole work on the sewer lines.
It's the manhole work. Thank you.
And on the water line, we had the well connection line freeze up, and that was kind of a major ordeal to get that thawed back out. And we had a section of it replaced, which would be the 3-inch, 4-inch supply line. We replaced over 100 feet of that.
100 feet. Thank you. But other than that, the system has been working.
Yeah. I mean, we've had normal things like trees falling on buildings, animals being removed from the pond, things that happen in a mountain system.
Okay. I want to turn to one more exhibit here. This is hearing exhibit 312, which is the San Juan County permit application packet. And Ms. Federico, if you could, Ms. Lynch, if you could bring that up and turn to page 45, please. This is a letter that you wrote, Mr. Marza, to the San Juan County Commissioners back in October last year. You see that?
Yes.
Okay. We included this in our SIR rebuttal testimony already, but I wanted to ask you a couple of questions about it. I want to see down here that you see in this paragraph. Can you scroll down a bit, Ms. Lynch? Where it says water here. You say here on the second line, the current 170 units use less than 120 gallons per day. Do you see that?
Yes.
Okay, so we've had a number of comments today about how many units there are that are being served by Grizzly Peak. And do we think it's 160 or is 170 the right number? Or is there a different number?
I think the major of the confusion actually happens because when you talk about units in water and sewer, we call them residential units.
Okay.
The actual physical tap is probably 170, but when you get into the units, a condo or a townhome is only considered 0.85 of a residential unit compared to a whole house. So there's discrepancy in what each person calls a unit.
Okay. So when you think when bills go out, do you know how many bills go out each month?
I don't, and I think that's the 170 number, but I'm not for certain
Okay.
because I don't do the billing.
Okay. Appreciate that. When
Some are grouped together,
some are grouped together, meaning
like CDOT, their resident is 5 or 7 units across the street, and that's just billed as one to CDOT.
okay.
App audit is what should be done to get an exact count.
You worked or talked to Right Water engineers when they were doing these couple of reports they've done for the utility?
Yes, I supplied them with quite a bit of information.
Did you give them this letter?
I believe so.
Okay. I want to look at the sewer paragraph right above here. You say that you're running at below 20% design capacity monthly. Do you see that?
that's on the design capacity of the sewer plant on our current permit, discharge permit.
So does that mean that you have 80% headroom?
Actually, at 80%, you're required to start redesign, and at 90, you're to be under construction or near complete construction. So the state doesn't let you run at 100% capacity.
Okay, so then you're at like 60% headroom before you get to 80.
Correct. Before we'd be mandated to build a new plant. Yes.
Okay. And you're saying that if you put 72 more units on this, that you're estimating you'd get to about that would take you up to 27.5.
Roughly, yes.
Roughly. Yeah. So we've talked a lot these standards that are about these environmental standards for PFAS that are upcoming. You're familiar with those?
Yep. We've done our current first sampling. We have to do another sample within 12 months. The
Okay.
wastewater, we haven't had to sample because that's on a sludge. That's not on a water basis.
Okay. So you've sampled the water side, but not the wastewater side. Is that what you're saying?
Correct.
Okay. And would that be because like PFAS are coming up in the wells themselves?
That's really kind of a discrepancy on where it's coming from. In our location, they're more concerned about firefighting foam and the use of it in the past as a additive to the firefighting.
Right. Okay, I'm familiar with
We've
that.
had a condo or two burned down. Forest fires in the area.
Okay. So, but you haven't done anything yet in terms of upgrading the plant for PFAS. Is that correct?
No, again, in wastewater, that is considered a sludge. When we go to haul the sludge, we'll have to figure out what our concentration of PFAS is when we finally dig out the lagoons and haul it out. That's an accumulative effect. So it's really when you start hauling it out is when you have to start worrying about it. More of an issue is the nutrients and the metals
Okay.
on the wastewater side.
And so that's all upcoming.
We're currently the permits under administration extension, and the new general permits do have metals and nutrient requirements that are in our existing permit as report only.
And so those are going to change to being control.
Correct. That was part of the engineering studies that Brightwater has done. Is it was in our compliance schedule to tell the state how we're going to comply with the new, as they call them, PELs, permit effluent limits, that they project that they will give us on the next permit.
Okay. Appreciate that. That is all the questions I have, Your Honor. Thank you very much, Mr. Marza.
Thank you. Mr. Larson, do you have some questions?
Yeah, thank you, Your Honor. Staff will actually waive cross on Mr. Marza.
All right. Well, I do have a couple of questions. I don't have many. Over here. So I just wanted to get some clarification between, in your testimony, you said something to the effect that the new CDPHE requirements are anticipated to become effective in 2026. Whereas then in the Brightwater engineer report, they said that more stringent limits took effect March 1st, 2025. Are those the same requirements, or are there two separate sets of requirements?
I believe that's the PFAS requirement you're talking about.
But I thought the PFAS was
That's
so
water.
the PFAS is the federal one that took place in 2025. Is that what you mean?
In the state, and of course, Colorado has jurisdiction, so the state is enforcing them. Yes, that's for PFAS. Like I said, we've sampled the first round. We have 24 hours. The wastewater, they've issued new general permits. Our permit is under renewal, and we're on administrative extension. for that at this current time because the
Okay.
permitting department is so overwhelmed.
Okay, so I think that was something I wasn't understanding. It's the CDPHE requirements are just enforcing the federal requirements, or they're
Correct.
okay.
CDPHE has to be more stringent than EPA because the Colorado has its own jurisdiction.
Okay, so it is they're the federal requirements, and then the state ones are more restrictive.
Correct.
Okay, and both are in effect at this time.
Correct.
But understanding your permit is on extension for renewal, and you're still report only. Okay.
I believe what Whitewater is talking about was the EPA did pass those in 25, 26. The state then in turn is enforcing them now. That's why we've got our compliance schedules that we're following and doing the testing for.
Thank you. Okay, I didn't quite understand that. And then in your testimony just now, you mentioned that CDOT is 5 or 7 accounts or units. Is that for sewer only, or is that also for water?
I believe that's just for sewer.
Okay.
Well, on the other side of the highway.
Thank you. Okay, and those were the only questions I had for you. So thank you. Mr. Davidson, if you wanted to do any redirect.
Just maybe a question or two, Mr. Marsa, when you were discussing with Mr. Detsky, the difference between the 20% level of capacity that you're at now versus what he called headroom to increase the usage of the wastewater treatment system. Is there a linear progression there? I mean, how do you calculate the amount of additional wastewater treatment necessary per new unit added, if you will, based on what you said in the letter that he referred you to?
The percentage that I was giving are the current numbers of flows that we have coming into the plant. The plant capacity is an engineering design that the plant was permitted for originally. That's 120,000 gallons a month. No, 120,000 gallons a day for an average on the month. The 20% is what we're doing right now of that 120,000 gallons that we're allowed to discharge. That's provided we can continue to meet the rest of the limitations that are in the permit. That is strictly the design capacity. That doesn't mean that we could actually meet it. And that's part of the problem that we're having is that original design was for the original lagoon, which the original plant isn't. And that's what Whitewater had to complete with the compliance schedule was to state how we were going to meet the new effluent limits that were given to us, which is why we're talking about having to replace or rebuild the plant, is because the plant currently cannot remove full nutrient, phosphorus, and some of the other new limits that are coming down the line that they've given us warning are coming, but they have not, of course, renewed our permit yet, so we don't have them yet.
And those new aspects of removal are applicable to the existing lagoon facility, correct?
Correct.
Okay. And so if you decide, if the CDPHE determines that for whatever reason not to renew your permit, what happens?
They wouldn't just not renew it. They would renew it with limitations and a compliance schedule that if you don't meet, they would in turn enact fines per day on you not meeting their requirements.
And what is a compliance schedule using that term?
What's listed in the permit when you get your renewal. It's things that you have to do. In our last one, we were told we had to do a mixing study of the stream, of the receiving stream. That was the first step. The second step was how we were going to meet the disinfection requirement because they changed our disinfection from the amount of E. coli that we could discharge from 2,000 down to less than 100. Our chlorine could no longer be discharged. We had to dechlorinate. So then we put in gaseous chlorine and gaseous sulfur dioxide to remove the chlorine. Those were two upgrades that it did in 2019. I want to say 2019, 2020, 2019. That was the first steps. Then we got the new permit that's got the metals and the total ammonia and nitrogen. And that's what Wrightwater is working on with their latest reports, is how to remove those. And in the cold weather, they listed multiple options of covering those current lagoons and doing a bunch of Band-Aids, or again, like we mentioned before, replacing or shipping it off to purgatory is one of the other things that they're looking at. Those are all the engineering questions, though.
As the system is presently configured, as I understand your testimony, it cannot manage the metals and nutrients that you just described adequately for purposes of renewal of the permit. Do I have that right?
For meeting the renewal, correct.
Yeah. Okay.
They will give us the renewal, but we have to meet it. And if we start having violations every month, that's when they'll come in with a new compliance schedule on. They won't. I've never seen them shut down a sewer plant, because obviously, what else are the people going to do? But they would impose fines and could bring in new management and take over the plant. But I don't think they go that far.
Okay, we like your management the way it is. We hope it's not replaced. Those are all the questions that I
I
have.
think they'd just start imposing fines. Yeah.
Okay, thank you. That's all I have, Your Honor. Thank you.
Thank you. I appreciate that. Thank you for your time, Mr. Marcia. And so you are excused at this point. We are coming up at 4:30. I defer to the parties. I'm happy to call it a day now, or we could begin the next phase and go until 5 o'clock. So staff, what would you prefer?
I think the next witness would be Mr. Borquette, correct? Or is it, I think we had switched the order, but it's of course your honor's prerogative.
If the parties wish to have Mr. Borquette go next, that is fine with me. And so I imagine he might be longer than staff's witness in terms of testimony. And so again, Mr. Detsky, do you have a preference for how to proceed, or anyone?
Yeah, my preference would be to start and end Mr. Borquette tomorrow, if that's possible. That way we don't break him up at the end of the day.
That works for me. Is that okay with you, Mr. Larson?
Yes, that works for us as well. Thank you, Your Honor.
And Mr. Davidson, is that good with you?
Yes, Your Honor, I'd prefer to just do the cross all at once and not have it broken in parts over the evening recess.
Yeah, that is my preference as well, but I wanted to defer to you because we could go on if everybody wanted to go on. Okay, well then why don't we break for the day, and then we will reconvene tomorrow at 9 o'clock and start with Mr. Borquette.
Sounds good. Thank you, Your
Great.
Honor.
Thank you for your time,
Thanks.
everyone.